What has happened in this case is, your lordship's order, my lord,
Buddy.
is in the review petition at page 8. I was a borrower. There were a number of proceedings against me. They brought my property to auction. At that stage, my lord, there were proceedings in DRT also. I was before your lordships. And before your lordships, my lord, I made a submission, the client made a submission that he will pay the admitted amount that was due with interest. Your lordships have recorded it, my lord, at page 8. The grievance of the petitioners against the coercive action of the bank, learned panel counsel having argued the matter, merely agrees to the suggestion of the court that petitioner shall make repayment of the entire amount due, including interest accruing thereon, outer limit of 4 weeks. Same shall be accepted by bank, no coercive proceedings taken. You have to deposit 10 lakhs within a week.
Correct.
No, I have filed a memo of calculation. Should be in your file, my lord. Memo of calculation.
Sorry. You have already filed it now.
Yes, it's already filed. There's also, my lord, the details of that are also there.
You want time?
Senior is in inconvenience mention in the post and history.
But you should have told the senior advocate when you were, you did not know that he will appear in this matter. We'll have it some other day. Till then, anything you are going to do? Interim order. We'll continue interim order. Please, whenever I sit single, we'll take up that. All right. Interim order to continue. First off, call when a judge of this court sits single. Come on, as requested by learned panel counsel appearing for the respondent bank. What? Then entire payment alla yenra martira.
Madbittidive. My lord, that's why I wanted to show, my lord, if a lordship just sees page number 24 on statement is there in the petition, review petition itself.
24.
So after your lordship's order, my lord, the payments at serial number 9, 10, 11, 12, 13 have all been made.
Total amount ಎಷ್ಟಿತ್ತು?
75 ಲಕ್ಷ ಇತ್ತು. More than 75 lakhs is paid, but interest accumulate ಆಗ್ತಾ ಹೋಗುತ್ತೆ.
2 ಕೋಟಿ 2 crores 45 lakh ಆಗ್ತದೆ.
45 lakhs.
ಅಮೌಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ.
ಅದಾಗೋಯ್ತು. DRT ಇರುವಾಗ DRT said balance due 75 lakhs. 75 lakhs ಕಟ್ಟಿದೀವಿ. Now more than that, my lord, your lordships had also directed interest. Interest saha pay ಮಾಡಿದೀವಿ. Only what remains now, my lord, is my client says that there is one amount due from the bank to us, which is towards some share deposit and all that. I have advised them, don't adjust all these things. You better pay that also. So now memo calculation hakidini. Other prakara, if I pay another 8 lakhs, which is taking note of the interest without insisting on adjustment of some other account, then everything is paid.
ಅದನ್ನು ವೇವ್ ಆಫ್ ಮಾಡ್ತೀರಾ?
ಅದನ್ನ ವೇವ್ ಆಫ್ ಮಾಡಕ್ ಕಷ್ಟ, ಯಾಕಂದ್ರೆ ನಮ್ ಶೇರ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಇದೆ, ಡಿವಿಡೆಂಡ್ ಬರ್ಬೇಕು. ಸೊ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ
ಎಷ್ಟಾಗತ್ತೆ ಅಂದಾಜು?
ಅದೇ ನಾವ್ 8 ಲಕ್ಷ ಅಂತ ಹೇಳಿದೀವಿ.
ಬಿಟ್ಟು ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಬಂದ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ನೀವೇ ಕೊಡೋದಿದೆ ಅಮೌಂಟ್ ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಪ್ಲೀಸ್. ಇಂಟ್ರಿ ಮಾಡ್ ಟು ಕಂಟಿನ್ಯೂ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಏನ್ ಬ್ಯಾಂಕ್ದ ಇಂಟ್ರೆಸ್ಟ್ ದುಡ್ಡು ಬರ್ಬೇಕು ಅಷ್ಟೇ. ಆ ಕಾರಣಕ್ಕೆ ಹಂಗೆ ಸೇಲ್ ಆಕ್ಷನ್ ಎಲ್ಲ ಮಾಡ್ಕೋತ ಹೋದ್ರೆ nobody will be safe. What is fun in having article 300 capital A? Yes.
But appear on behalf of the petition. Lord, this is the sugar factory matters, my lord, which your lordships had heard. Where the cane.
ಹೇಳ್ಬಿಡಿ. We were in fact waiting. Of course, you maintain equidistance from both the sides. Mr. Holla, we will complete this matter today.
Yes.
Come.
In fact, your lordships have noted down my submissions on the last time.
ಅವರು ಉತ್ತರ ಕೊಡ್ಬೇಕು.
Yes.
Already ಇರಲಿಲ್ಲ ಅವರು.
ಹೌದು.
He was held up in some other place.
Lordship recollects, Lordship had
ನೀವು ಡಾಟಾ
directed
ಕೊಡ್ರಿ ಅಂತ
the
ಹೇಳಿ.
director of the research institute to be
ಬರಕ್ಕೆ
present.
ಹೇಳಿದ್ವಿ.
The former director and technical advisor is present.
ಹಾ.
Lordship had asked how many days.
ನಮ್ದೇನಿತ್ತು ಮಿಸ್ಟರ್ ಹೊಳ್ಳ?
Please.
Coexistence.
ಗೊತ್ತಾಯ್ತು. That, my lord.
Very important. We should coexist.
Correct.
That's the rule of nature. This Darwin says in his Origin of Species. Whichever species tried to coexist with other species, they flourished ಅಂತ ಬರೀತಾನೋ. ಡಾರ್ವಿನ್ನ ವಿಕಾಸವಾದದಲ್ಲಿರುವಂತಹ ಒಂದು ಐಡಿಯಾ. Therefore, whether both these factories can coexist,
ಒಂದು ರಿಪೋರ್ಟ್ ಮುಂಚೆ ಹಾಕಿದ್ರೆ ಆಗಲ್ಲ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅದೇ ಅವ್ರು ಬಂದಾರೆ, ಡೈರೆಕ್ಟರ್ ಯಾರೋ ಬಂದಾರೆ,
ನಾವೇ ಕೇಳಿ.
ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ.
Sir, myself CB Patil. I am
Hey.
technical advisor of S. Nizlingappa Sugar Institute, Belagavi.
ಹಾ,
Sir, I have served.
ಕನ್ನಡದಲ್ಲೇ ಹೇಳ್ರಿ, ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ತದೆ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಇವಾಗ ನಮಗೆ ಒಂದು ಹೊಸ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಬೇಕಾಗಿದ್ರೆ
ಹಾ,
ನಾವು ಮೊಟ್ಟ ಮೊದಲಾಗಿ ಇಲ್ಲಿ ಏನ್ ಮೂಲ ಸೌಕರ್ಯಗಳು ಬೇಕಾಗ್ತಾವ, ಫಂಡಮೆಂಟಲ್ ನೀಡ್ಸ್ ಏನ್ ಬೇಕಾಗಿರೋದು, ಒಂದು ಕೇನ್ ಏರಿಯಾ,
ಏನ್ ಗ್ರೋಯಿಂಗ್ ಏರಿಯಾ ಬೇಕು,
ಕೇನ್ ಗ್ರೋಯಿಂಗ್ ಏರಿಯಾ,
ಒಂದು
ಇರಿಗೇಬಲ್ ಇರ್ಬೇಕ್ರಿ ಅದು.
ಏನ್ ಗ್ರೋಯಿಂಗ್ ಏರಿಯಾ, ಅದೇ ಅದು ಕ್ರೇನ್ ಗ್ರೋಯಿಂಗ್ ಅಂದ್ರೆ ಎಲ್ಲ ಬಂದ್ ಹೋತ್.
ಇರಿಗೇಷನ್ ಅದು 12 months ಇರ್ಬೇಕ್ರಿ, ಅಂದ್ರೆ ಪಾರ್ಷಿಯಲಿ ಇರಬಾರ್ದು. 12 months ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಎ
ಇರಿಗೇಷನ್ ಫೆಸಿಲಿಟಿ ಫಾರ್ 12 months. ಒಂದ್ ನಿಮಿಷ,
ಇಟ್ ಶುಡ್ ಬಿ ನಿಯರ್ ಟು ದಿ
ಇರಿಗೇಷನ್ ಫೆಸಿಲಿಟಿ ಇದ್ಬಿಟ್ರೆ ಆಗಿತ್ತು, ರಿವರ್ ಇರ್ಲಿ ಇನ್ನೊಂದ್ ಕಡೆ ಇರ್ಲಿ, ಇರಿಗೇಷನ್ ಫೆಸಿಲಿಟಿ ಫಾರ್ 12 months. ರಿವರ್ ಇರ್ಬೇಕು ಅಥವಾ ಬೋರ್ವೆಲ್ ಇರಬಾರ್ದು ಅನ್ಕೊಂಡು ಇದೇನು ಹಂಗೇನಿಲ್ಲ.
ಆ ಬೋರ್ವೆಲ್ಸ್ ಅನ್ಸರ್ಟನ್ಟಿ ಇರ್ತದ್ರಿ, ಬೇಸಿಗೆಯಲ್ಲಿ ಡ್ರೈ ಆಗೋ ಚಾನ್ಸಸ್ ಇರ್ತದೆ,
ಗ್ಯಾರಂಟಿ ಇರಲ್ಲ.
ಗ್ಯಾರಂಟಿ ಇರೋದಿಲ್ಲ. ಮತ್ತೆ ನಮ್ ಶುಗರ್ ಕೇನ್ ಸೀಸನ್ ಇರೋದು ನವೆಂಬರ್, ಡಿಸೆಂಬರ್, ಜನವರಿ, ಫೆಬ್ರವರಿ, ಮಾರ್ಚ್, ಏಪ್ರಿಲ್.
ಕೇನ್ ಇಯರ್ ಅಂತ ಏನ್ರೆ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಆಗಿದೆ ಏನು?
ಕೇನ್ ಏರಿಯಾ,
ಕೇನ್
ಇಯರ್
ಇದು ಏನು ಇಯರ್ ಹೆಂಗ್ ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್, ಅಸೆಸ್ಮೆಂಟ್ ಇಯರ್,
ಅದು ಅಕ್ಟೋಬರ್ ಟು ಸೆಪ್ಟೆಂಬರ್ 31st.
ಕೇನ್ ಇಯರ್.
ಎಸ್,
Crushing.
ಕ್ರಶಿಂಗ್
Crushing year.
ಶುಗರ್ ಅಂಡ್ ಕೇನ್ ಕ್ರಶಿಂಗ್ ಸೀಸನ್ ನಾವು ಇದು ಅಂತೀವಿ, ಅವಧಿ ಏನಂತೀವಿ, ಪೀರಿಯಡ್.
ಅದು ಅಕ್ಟೋಬರ್ ಟು
ಮಾರ್ಚ್, ಸೆಪ್ಟೆಂಬರ್ 31st.
ಹೆಂಗೆ
ಸ್ಟಾರ್ಟ್ ಆಗಿರೋದು ಅಕ್ಟೋಬರ್ 1st ಗೆ, ಎಂಡ್ ಆಗೋದು ಸೆಪ್ಟೆಂಬರ್
30th ಸೆಪ್ಟೆಂಬರ್.
30th ಸೆಪ್ಟೆಂಬರ್.
ಅಂದ್ರೆ 2 ತಿಂಗಳು ಅಷ್ಟೇ ಇರ್ತದೆ ನದು.
ಇಲ್ಲಲ್ರಿ, 12 months ಅದು ಸೈಕಲ್, ಒಂದ್ ಸೈಕಲ್.
April to
ಹೋಲ್ ಇಯರ್ ಇಟ್ ಈಸ್. ಓಕೆ, 1st ಅಕ್ಟೋಬರ್ ನಿಂದ 30th ಸೆಪ್ಟೆಂಬರ್ ಆಫ್ ನೆಕ್ಸ್ಟ್ ಇಯರ್. ಆಲ್ ರೈಟ್.
ಈ ಅವಧಿಯಲ್ಲಿ ನಾವು ಹಾರ್ವೆಸ್ಟಿಂಗ್ ಮಾಡ್ತಿರೋದು ನವೆಂಬರ್ ಮಂತ್ ನಿಂದ.
ನವೆಂಬರ್ ನಿಂದ ಹಾರ್ವೆಸ್ಟಿಂಗ್ ಆಗ್ತದೆ.
ಎಸ್ ಸರ್.
ಅಂದ್ರೆ ಕಟಾವ್ ಅಂತ ನಾವೇನ್ತೀವಿ.
ಕಟಾವ್ ಮಳೆಗಾಲ ಇವಾಗ ರೇನ್ಸ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ತಾ ಇರಬೇಕು, ಅವಾಗೆ ನಾವು ಅಕ್ಟೋಬರ್ 15 ದಿಂದ ಸರ್ವೆ ಮಾಡ್ತೀವಿ, ಮ್ಯಾಚುರಿಟಿ ಸರ್ವೆ ಅಂತೀವಿ ನಾವು ಅದಕ್ಕೆ. ಸೊ ಸರ್ವೆ ಮಾಡಿ ದಿ ಮೋಸ್ಟ್ ಎಕನಾಮಿಕಲ್ ಅಂಡ್ ವಯಬಲ್ ಪೀರಿಯಡ್ ಶುಡ್ ಬಿ ನವೆಂಬರ್ ಟು ಮಾರ್ಚ್, ಏಪ್ರಿಲ್.
ಕಟಾವ್ ಮಾಡುವಂತ
ಪೀರಿಯಡ್ ರೀ.
ನಾನು ಅಗ್ರಿಕಲ್ಚರ್ ಫ್ಯಾಮಿಲಿಯಿಂದನೇ ಬಂದೇನೆ, ಹಂಗಾಗೆಲ್ಲ ಅರ್ಥ ಆಗ್ತದೆ ಇದು.
ಹೌದು ಸರ್.
ನವೆಂಬರ್ ಟು
ಏಪ್ರಿಲ್ 15th ಆರ್ ಮೇ,
ಅಲ್ಲಿ ತನಕ ಡ್ರೈ ಆಗಲ್ಲ ಅನ್ನೋದು ಹಾಗೆ ನಿಂತ್ಕೊಂಡ್ರೆ.
ಹಾಗೇನೆ ಇಲ್ಲಾಂದ್ರೆ ಆಸ್ ಮಚ್ ದಿ ನಂಬರ್ ಆಫ್ ಕ್ರಾಪ್ ಡೇಸ್ ಹೆಚ್ಚಿಗೆ ಇದ್ದಾಗ ಅದು ಶುಗರ್ ಕೇನ್ ನಾವು ಕೊನೆಗೆ ಇವಾಗ ಎಕ್ಸ್ಪಾನ್ಷನ್ ಆಗಿ ಜಾಸ್ತಿ ದೊಡ್ಡ ಪ್ರಮಾಣದಾಗೆಲ್ಲ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಎಕ್ಸ್ಪಾನ್ಷನ್ ಆಗಿ ಕ್ರಾಪ್ ಡೇಸ್ ಕಡಿಮೆ ಆಗಿದಾವ್ರಿ. ನಾವು ಹಿಸ್ಟ್ರಿ ತಗೊಂಡಾಗ 140 days is the minimum. Maximum 160, 165 days.
ನವೆಂಬರ್ ಟು ಮೇ ಅಂತ ಅನ್ಕೊಳ್ಳೋಣ.
ನವೆಂಬರ್ ಟು ಮೇ.
ಆಲ್ ರೈಟ್.
ಹಾ ಸರ್. ಮತ್ ಇವಾಗ IM ಪ್ರಕಾರ ನಾವೇನ್ 15 kilometer ರೇಡಿಯಸ್ನ್ಯಾಗ
IM ಏನದು?
ಇಂಡಸ್ಟ್ರಿಯಲ್ ಮೆಮೋರಿಯಂ
Entrepreneurial memorandum. Issued by Industrial Entrepreneurial Memorandum. IEM.
ಆದ್ರೆ ನಾವು ಇವಾಗ ಯಾರೇ ಹೊಸ ಯೂನಿಟಿಗೆ ಅಪ್ಲೈ ಮಾಡುವಾಗ IM ತಗೋಕ್ಕಿಂತ ಮುಂಚೆ ಡಿಸ್ಟೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೋತೀವಿ. ಡಿಸ್ಟೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಒಂದ್ ಚಿಮ್ನಿ ನಾವು ಎಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ಆ ಚಿಮ್ನಿ ಸೆಂಟರ್ ಹೈಟ್ ನಿಂದ ಇನ್ನೊಂದು ಫ್ಯಾಕ್ಟರಿ ಯಾವ್ದು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಅಲ್ಲಿ ಮಿನಿಮಮ್ 15 kilometers ಆಗಿರ್ಬೇಕು.
ನಡುವೆ ಎರಡು ಫ್ಯಾಕ್ಟರಿಗಳ ನಡುವೆ
ಅದಕ್ಕೆ ಚಿಮ್ನಿ ನಾವು ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೋತೀವಿ. ಬೆಂಚ್ ಮಾರ್ಕ್ ಮಾಡ್ಬೋದು ಚಿಮ್ನಿ ಹೈಟ್, ಚಿಮ್ನಿ ಸೆಂಟರ್.
ಆಲ್ ರೈಟ್.
ಸೊ ಈ ಒಳಗಡೆ ಇದ್ದಂತ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಯಾರಾದ್ರೂ ಅದಕ್ಕೆ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ತೀವಂದ್ರ ಅದಕ್ಕೆ ಇದು ಕ್ಲಾಸ್ ನ್ಯಾಗ ಕೊಡೋದಿಲ್ರಿ. ಇಟ್ ಈಸ್ ವೈಲೇಷನ್ ಆಫ್ ದಿ ಕ್ಲಾಸ್. ಇವಾಗ
it is Mr. Holla, it is little contrary to Gloucester Grammar School case perhaps. In Gloucester perhaps you may be aware, where another school came to be established, students went there, he went in told, court said damnum sine injuria, there is damage but no injury. That way this is reverse of that now. 15 kilometers it has to be. Yes,
has to be. ಇದ್ರೊಳಗೆ ಈ ರೇಡಿಯಸ್ನ್ಯಾಗ ಎಷ್ಟು ಹೆಕ್ಟರ್ಸ್ ಏರಿಯಾ ನಮಗೆ ಸಿಗುತ್ತೆ ಇವಾಗ ನಮ್ ಕರ್ನಾಟಕದ ಒಂದು ಜಿಯೋಗ್ರಫಿಕಲ್ ಮ್ಯಾಪಿಂಗ್ ತಗೋಯ್ತಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಟಿದಾರ್ರಿ ಆಕ್ಚುಲಿ ಸರ್ವೆ ಮಾಡಿ ಕೊಟ್ಟಿದಾರ.
ಹಾ.
ಇಟ್ ಶುಡ್ ಬಿ 80% ಇರಿಗೇಬಲ್ ಲ್ಯಾಂಡ್ ಇರ್ಬೇಕು. ಅಂದ್ರೆ ಇವಾಗ 7.5 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಸ್ನ್ಯಾಗ ಇದು
Diameter ನಲ್ಲಿ
ರೇಡಿಯಸ್ ನಲ್ಲಿ ನಮಗ್ ಸಿಗುವಂತ ಏರಿಯಾ ಇನ್ ಹೆಕ್ಟರ್ಸ್ನ್ಯಾಗ 17,500 100% ಇದ್ದಾಗ
ಹ್ಮ್.
80% ತಗೊಂಡು ಅಂದ್ರ
ನೀವು ಡಯಾಮೀಟರ್ ಅಂತಂದ್ರೆ ಅದು ತ್ರಿಜ್ಯ ನೀವು
ತ್ರಿಜ್ಯ,
ಹೇಳಿದ್ದೀಗ
ತ್ರಿಜ್ಯ.
ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ವ್ಯಾಜ್ಯ ಅಂತ ಹೇಳ್ತಾ
Yes, sir.
ಇದ್ದಾರೆ. ಹಾ.
ಅದು ಆ ಫ್ಯಾಕ್ಟರಿ ಚಿಮ್ನಿ ಡಿಸ್ಟೆನ್ಸ್ ನಿಂದ ಆ ಏರಿಯಾ ಏನು 7.5 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತಲ್ಲ 15 ಕಿಲೋಮೀಟರ್ ಅಂದ್ರೆ 7.5
ಓಕೆ
7.5 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸುಮಾರವಾಗಿ 17,500 ರಫ್ಲಿ ಲ್ಯಾಂಡ್ಸ್ ಹೆಕ್ಟರ್ಸ್ ಬರ್ತದೆ. ಅದ್ರ 80% ಅದ್ರ 14 ಬರುತ್ತೆ. 14 100% ಇರಿಗೇಷನ್ ಲ್ಯಾಂಡ್ನಾಗ ಬೇರೆ ಅದರ್ ಕ್ರಾಪ್ ಒಂದು 20 ಲೆಸ್ ಮಾಡ್ತೀವಿ ನಾವು. ಸೊ ಅದ್ 60% ತೊಗೊಂಡ್ರು 11,000 ಹೆಕ್ಟರ್ ನಮ್ಗೆ ಸಿಗುತ್ತೆ. 11,000 ಹೆಕ್ಟರ್ನಾಗ ನಾವು ಶುಗರ್ ಕೇನ್ ಬೆಳೆದು ಅಂದ್ರೆ 7.5 ಲಕ್ಷ ನಮಗೆ ಕೇನ್ 80 ಈಲ್ಡ್ ತಗೊಂಡು ಅಂದ್ರೆ ಸುಮಾರವಾಗಿ ಒಂದು 7.5 ಲಕ್ಷ ಕೇನ್ ಅವೈಲೇಬಲ್ ಸಿಗುತ್ತೆ. ಸೊ ಈ ಮಾದರಿ ಒಳಗೆ ನಾವು ಮಾಡಿದ್ರಿ ಅಂದ್ರೆ ಆಕ್ಚುಯಲ್ ಫಿಸಿಕಲ್ ಸರ್ವೆನು ಮಾಡಬಹುದ್ರಿ.
ಹಾ.
ಇದು ಈ ತರ ಇರುತ್ತೆ ಅಂತೇಳಿ ನಮ್ ಕರ್ನಾಟಕದ ಬ್ಯಾರೆ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿದೆಲ್ಲ ನಾವು ನೋಡ್ಕೋತೀವ್ರಲ್ಲ. ಇದು ಸಮೀಪ ಇದೆ ನಮ್ ಕರ್ನಾಟಕ ಜಿಯೋಗ್ರಫಿಕಲ್ ಇದ್ರೊಳಗ
Okay.
ಇಷ್ಟು ನಾವು ಕನ್ಸಿಡರೇಷನ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ.
ಓಕೆ
ಸೊ ಈ 7.5 ಲಕ್ಷ ಅವೈಲಬಿಲಿಟಿ ಸಿಕ್ಕಾಗ
ಹಾ.
5,000 ಕೆಪಾಸಿಟಿಗೆ ಅದು ಸೀಮಿತ
ನಡೀತದೆ.
ಆಗುತ್ತೆ. ಆಮೇಲೆ 140 ಡೇಸ್ ನಡಿಬೇಕ್ರಿ ಮಿನಿಮಮ್.
ಓಕೆ
ಅವಾಗ ಅವರೇಜ್ ಈಲ್ಡ್ನು ಜಾಸ್ತಿ ಅದು ಫ್ಲಕ್ಚುಯೇಷನ್ ಇರುತ್ತೆ. ಒಮ್ಮೆ 75 ಬರ್ಬೋದು, 85 ಬರ್ಬೋದು, 90 ಬರ್ಬೋದು. ಇಟ್
ಸ್ವಲ್ಪ
ಡಿಪೆಂಡ್ಸ್ ಆನ್
variation.
ಕ್ಲೈಮ್ಯಾಟಿಕಲ್ ಕಂಡೀಷನ್ ಅಂಡ್
Yield
ಅವೈಲಬಿಲಿಟಿ
ಮೇಲೆ depend.
ಈಲ್ಡ್ ಮ್ಯಾಗ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಹೊಸ ವೆರೈಟಿನೂ ಬರ್ಬೋದ್ರಿ. ಸೊ ಹೀಗಾಗಿ ಈ 7.5 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯ ಇದು ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಬೇಕು. ಆಮೇಲೆ 15 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿ ಡಿಸ್ಟೆನ್ಸ್ ಟು ಡಿಸ್ಟೆನ್ಸ್ ಅಷ್ಟು ಇದ್ದಿರ್ಬೇಕು. ಸೊ ಇಟ್ ವಿಲ್ ಗಿವ್ ಅ ಫೈಬಲ್. ಆಮೇಲೆ ಶುಗರ್ ರಿಚ್ ವೆರೈಟೀಸ್ ಮಾಡಬೇಕು. ಅದು ಪ್ರೋನ್ ಟು ಸಬ್ಜೆಕ್ಟು ಆ ನೇಬರಿಂಗ್ ಏರಿಯಾದಾಗ ಶುಗರ್ ಕೇನ್ ರಿಕವರಿ ಚೆನ್ನಾಗಿರ್ಬೇಕು.
ಓಕೆ
ಸೊ ಅದು ಈ ತಮಿಳುನಾಡು ಅಲ್ಲಿ ಕೆಲವು ಡೈವರ್ಸಿಫಿಕೇಶನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಕ್ರಾಪ್. ಆ ತರ ಇದ್ದಿರಬಾರ್ದ್ರಿ. ರಿಕವರಿ ಶುಡ್ ಬಿ 11+ ಆಗಿರ್ಬೇಕು, ಅವರೇಜ್ ರಿಕವರಿ.
Okay.
ಆಮೇಲೆ ಅದು ಈ ನೀರಿನ ವ್ಯವಸ್ಥೆ 12 ಮಂತ್ಸ್ ಇದ್ದಿರ್ಬೇಕು.
Okay.
ಜೊತೆಗೆ ಏನು ಅಂತಾವು ಅದ್ ಕ್ಲಾಸ್ನ್ಯಾಗ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡು ಮೊನ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಅವು ಇದ್ದಿರ್ಬಾರ್ದ್ರಿ. ಸೊ ದೇರ್ ಶುಡ್ ಬಿ ಕ್ಲಸ್ಟರ್ ಆಫ್ ಬ್ಯಾರೆ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಹತ್ತಿರದಾಗ ಇದ್ದಿರ್ಬಾರ್ದು. ಅವ್ರಕೇನ್ ಅಲೋಕೇಶನ್ ಏನ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅದ್ ಮತ್ತೊಮ್ಮೆ ಜಡ್ಜ್ ಮಾಡ್ಬೇಕ್ರಿ.
ಓಕೆ
ಸೊ ಇದ್ರೆ ಯಾರು ಹೊಸ ಶುಗರ್ ಯೂನಿಟ್ ಹಾಕುವವರಿಗೆ ಮೋರ್ ವಯಬಲ್ ಅಂಡ್ ಮೋರ್
ಈಗ
ಫಿಸಿಬಲ್.
ಈ ಎಲ್ಲ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ನೀವು ಹೇಳಿದ್ರಲ್ಲ, ಈ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಹೇಳಿದ್ರಲ್ಲ ಈಗ,
ಹಾ ಸರ್.
ಇವುಗಳನ್ನೆಲ್ಲ ಹಿನ್ನೆಲೆಯಲ್ಲಿ
ಹಾ,
ಈ ಎರಡು ಫ್ಯಾಕ್ಟರಿಗಳು ಜೊತೆಗೆ ಇರ್ಲಿಕ್ಕೆ ಆಗ್ತದ ಇಲ್ಲ?
ಸರ್ ಅವ್ರದ್ದು ನಮ್ಗೆ ಹಿಸ್ಟ್ರಿ ಗೊತ್ತಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ.
ಬಟ್ ಇವಾಗ ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದ್ರೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಯಾರು ಸೀರಿಯಸ್ಲಿ ಅದಕ್ಕೆ ಎಫರ್ಟ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಅವ್ರಿಗೆ ನೀವು ಅವಕಾಶ ಮಾಡಿಕೊಡ್ಬೋದ್ರಿ. ಇವಾಗ ಲಾಸ್ಟ್ ಯಾರೋ ಒಬ್ರು ಬರೇ ಇನ್ನೊಬ್ರಿಗೆ ಮಾಡುವಂಗಿಲ್ಲ ಮತ್ತೆ ಅಲೋಕೇಶನ್ ಹಂಗೂ ಇದಾರ ಬಹಳಷ್ಟು ಕೇಸ್ನವ್ರು. ಇನ್ನೊಬ್ರಿಗೆ ಅವಕಾಶ ಕೊಡ್ಬೇಕು. ಯಾರು ಮೋರ್ ಸೀರಿಯಸ್ ಇದಾರ ಅವ್ರ ಪ್ರಿವಿಯಸ್ ಹಿಸ್ಟ್ರಿ ಎಲ್ಲ ತಗೊಂಡ್ ನೋಡ್ಕೋಬಹುದ್ರಿ. ಅವ್ರು ಎಷ್ಟು IM ತಗೊಂಡ್ಮೇಲೆ ಆಕ್ಟಿವಿಟೀಸ್ ಎಲ್ಲ ಅದು ಇವಾಗ ಫಸ್ಟ್ 2 yearsನಾಗ ನಾವೆಲ್ಲ ಮಷಿನರಿ ಆರ್ಡರ್ಸ್ ಮಾಡಬೇಕು. ಆಮೇಲೆ ಲ್ಯಾಂಡ್ ಪರ್ಚೇಸ್ ಮಾಡಿರ್ಬೇಕು,
ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಎಲ್ಲ
ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಹಾಕಿರ್ಬೋದು. ಮಷಿನರಿ ಸಪ್ಲೈ 18 ಮಂತ್ಸ್ ತಕ ಆಗ್ತಾವ ಈ ಟರ್ಬೈನ್ ಎಲ್ಲ ರೀ. ಇನ್ಸ್ಟಂಟ್ಲಿ ಅವು ಆಗೋದಿಲ್ಲ. ಇಟ್ ವಿಲ್ ಟೇಕ್ 2 years ಮಿನಿಮಮ್. ಸಪ್ಲೈ 16 ತಿಂಗಳು ಬೇಕಾಗುತ್ತೆ ರೀ. ಟರ್ಬೈನ್ ಎಲ್ಲ ಕ್ರಿಟಿಕಲ್ ಇಕ್ವಿಪ್ಮೆಂಟ್ಸ್ ಅವ್ರ ಮೊದಲೇ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಜಸ್ಟೇಷನ್ ಪೀರಿಯಡ್ 2 ವರ್ಷ ಇದೆ.
2 ವರ್ಷ ಇದೆ. ಅದ್ರೊಳಗೆ ಒಂದೊಂದು ಇಕ್ವಿಪ್ಮೆಂಟ್ಸ್ ಡೆಲಿವರಿ ಪೀರಿಯಡ್ 16 ತಿಂಗಳದೆ. ಇವತ್ತು ಆರ್ಡರ್ ಮಾಡ್ರಿ ಅಂದ್ರೆ ಸೊ ಅವ್ರಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಮೊದಲ. ಈ ಕಂಡೀಷನ್ಸ್ ಎಲ್ಲ ಹೇಳೋದು ಯಾಕೆ ಉದ್ದೇಶ ಅಂದ್ರೆ ಯಾರು ಸೀರಿಯಸ್ ಅದಾರ ಅಂತ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಮಾಡಿ
ಅವ್ರಿಗೆ ಮಾತ್ರ ಆಗ್ತದೆ
ಮಾಡ್ಬೋದ್ರಿ. ಆಮೇಲೆ ಲೈಸ್ನಿಂಗು, ವಾಟರ್ ಇರಿಗೇಷನ್, ಕೇನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕು ಮೊದಲು. ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ಬರೋಕ್ಕಿಂತ ಮುಂಚೆ 2 years ಬಿಫೋರ್ ಕೇನ್ ಏರಿಯಾ ಡೆವಲಪ್
ಆಗ್ಬೇಕು.
ಇಲ್ಲಾದ್ರೆ ಎಲ್ಲಾರು
2 ವರ್ಷ ಉಳಿತು.
ಎಸ್ ಸರ್.
ಇದು 1 year ಕ್ರಾಪ್. ಇದು
1 year ಕ್ರಾಪ್ ರೀ. 12 months ಪ್ಲಸ್ 14 ತಿಂಗಳು 16 ತಿಂಗಳು ಬಂದವ್ರಿ ಇವಾಗ. ಮಿನಿಮಮ್ ಈಸ್ 12 months, ಮ್ಯಾಕ್ಸಿಮಮ್ 14 months. ಸೊ ಮಿಡ್ಲೇಟ್ ವೆರೈಟೀಸ್ ಈಗ ಹಾಕ್ತಿರ್ತಾರೆ. ಮೊದಲು ಕೇನ್ ಏರಿಯಾ ಡೆವಲಪ್ ಮಾಡ್ಕೋಬೇಕ್ರಿ. ಆಮೇಲೆ ಮಷಿನರಿ ಅಂಡ್ ಲ್ಯಾಂಡ್ ಪರ್ಚೇಸ್ ಮಾಡಿರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಇದು ಇವಾಗ ಮಷಿನರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿರ್ಬೇಕು. ಸೊ ಇವೆಲ್ಲ ಆಕ್ಟಿವಿಟೀಸ್ ಮಿನಿಮಮ್ ಸ್ಟಾಫ್ ಎಂಗೇಜ್ ಮಾಡಿರ್ಬೇಕು. ಸಿವಿಲ್ ವರ್ಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿರ್ಬೇಕು. ಫೌಂಡೇಶನ್ಸ್ಗೆಲ್ಲ ಟೈಮ್ ತಗೋತದ. ಅದು ಮಳೆಗಾಲನ್ಯಾಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಅದು ಸಮ್ಮರ್ನ್ಯಾಗ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಯಾರು ಸೀರಿಯಸ್ ಅದಾರ ಅಂತ ಅವ್ರಿಗೆ ಅವಕಾಶ ಕೊಡ್ಬೋದು.
Thank you. Shri, so and so, on request came before the court and assisted in the proceedings by furnishing valuable information and statistics in relation to intended establishment of sugar factories. First, this court places its deep appreciation for him. Okay, registry to share a copy of this order with Sri Science Societies. Okay, Ardun Hesaru.
Yes, but furnished.
Right. Yes, sir.
Lord, the sugarcane control order,
You want him to refresh your, so that it becomes easy for you, Mr. Hulla?
ಆಗ್ಬೋದು sir.
Or you want
No, no.
to go on?
ಇಲ್ಲ ನಾನು ಮಾಡಬಹುದು.
ಹಾ.
ಅಲ್ಲ ತಮಗೇನಾದ್ರೂ ಬೇಕಾದ್ರೆ
ಇಲ್ಲ, ನನ್ಗೇನ್ ಬೇಕಾಗಿಲ್ಲ. ನನಗೆ ಎಲ್ಲ ನೆನ್ಪು ಬಿಡ್ತದೆ.
Your
Unfortunately.
Lordships actually, my lord, dictated the submissions made, but I can very.
ಅಲ್ಲ ಅಂದ್ರೆ ಒಳ್ರ ಅವತ್ತು.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ.
ಅದಕ್ಕೆ ನೀವು ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ.
I can.
That becomes easy for him.
Yes.
No
to-
difficulty.
To meet those points.
So only, yes, only 2-3 things I would like to say.
Head.
My lord, the IM which was given to us on 13/8/2010. And on 9/9/2010, a bank guarantee of 1 crore was paid.
Given to you on?
On 13/8/2010, annexure F, page 54. And bank guarantee was paid, we are supposed to pay it within a month. We paid that as per annexure G, page 56 of 1 crore on 9/9/2010.
Annexure,
Annexure G. Then, my lord,
page number?
page 56.
Okay.
We could not set up a factory for various reasons, my lord. I'll not go into all that because of this. 2012/2018, annexure J, page 61. R2 derecognized our IM.
Who is the authority to derecognize
That
actually?
is the CDS, Chief Director of
Your
Sugar.
case is he does not have jurisdiction.
Cane Commissioner will not.
Who will have power?
Well, the power would vest with the CDS as per 6C and
central government, my lord.
central
The
government.
government.
Because IEM is issued by the central government.
So it is for them to.
That's right.
So, my lord, this order of derecognition. The order of derecognition was challenged by the petitioner by filing writ petition number 440 of 2019, which, my lord, was allowed by the learned single judge, vide order dated 14/8/2019.
Really, no.
Annexure L, page 67. And in this, my lord, there was an interim order operating during the pendency of the writ petition. And this was with a detailed order, my lord, the writ petition came to be allowed. The derecognition order was quashed. And, my lord, the CDS, respondent number 2, was directed to pass order, a speaking order within 6 weeks. para 6 of the learned single judge's order.
In view of the submissions made, taken into account, signed so. Not been taken into account by the company that the impugned order is hereby quashed, set aside, directed to consider case of petitioner afresh in the light of notification dated 24/8/2016 by which was amended in particular in the light of the provisions of clause 6C of sugar control amendment order to the by a speaking order within a period of 6 weeks from today.
Then
This direction was issued to whom?
My lord, this was to respondent number 2.
But you said the respondent number 2 has no jurisdiction at all.
Kane Commissioner.
Kane
And the
Commissioner.
R3.
R3,
R3 is the Kane Commissioner, the state
R2 is central government.
central government. So, and if your lordship just sees the next.
So
one-
derecognizing IAM was R3,
No, R2,
R2.
R2.
Who is R2?
R2 is the CDS, the Chief Director of Sugar Central Government.
He has no,
He
but
has the powers. He is the one who gives the IEM,
who derecognized IAM?
R2.
R2.
Yes, sir.
Once it, he is competent authority to issue it,
Yes, sir.
but he has no power to rescind it.
He can. He derecognized.
But you argued that he has no jurisdiction at all.
Kane Commissioner, I'll come to that.
Okay.
So this order, my lord, the learned single judge, your lordship, my lord, saw that. So within 6 weeks, he must pass that order. Interim order granted earlier.
Andre,
continue.
ಕೂತ್ಕೊಳ್ಳಿ ಮುಚ್ಚಳಿ ಪಾಪ ಯಾಕೆ ನಿಂತ್ಕೊತೀರ necessarily. ಕೂತ್ಕೊಳ್ಳಿ.
So my lord,
Yes.
he, the learned
ಈ
single judge, my lord.
ಬೋರ್ಡ್ ಇಷ್ಟು ದೊಡ್ಡದು ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಕಾಣುವುದಿಲ್ಲ.
ಕಾಣೋದಿಲ್ಲ ಹಾಗೆ ಅಷ್ಟೇ ಪರವಾಗಿಲ್ಲ.
But nobody can ignore your presence. Yes.
So my lord, within 6 weeks, he was supposed to have passed the order and the interim order continued. So one submission is that since the derecognition was washed and it was stayed, so it is in currency, my lord, the IEM is in currency, so nobody else can get it during that time. Then my lord, no orders were passed on after the orders passed by this. In the meanwhile, my lord, what we had also done was, since we were not aware as to what is transpiring and what is happening, we made one more application, my lord, for grant of distance certificate.
It is another certificate.
Another certificate, my lord, there was no impediment for us to take because the only thing is if somebody else has filed, it is first come, first served. If somebody else has come, then since, my lord, this was, nothing was happening here, we made an application. That was not considered. In the meanwhile, my lord, they also filed an application after our application. Then, my lord, the learned single judge in a writ petition said that the application filed has to be considered. There, my lord, then what the Kane Commissioner, my lord, does, that is the respondent number 3, the order which is impugned before your lordship, my lord. When in the teeth of the order passed by this honorable court that the
In WP,
the learned single judge where he has quashed the derecognition and sent the matter back, my lord, the Kane Commissioner says your IEM is derecognized by operation of law because of 6D. So
clause 6D
yes. So he says because
of
it is
amended order.
yes. So he says that it is automatically derecognized. First of all, my lord, he does not have the jurisdiction. Second, that already that issue or derecognition, my lord, was already set aside by this honorable court. And that matter was pending whether my IEM should stand revived and whether I should be given an extension or not, my lord, that was for the
Central government has to decide.
So in that, my lord, he passed this order, that order we have challenged. Then what happened, my lord, when this matter was pending before this honorable court, since he had not passed, this honorable court, my lord, was upset with them and directed him to immediately pass orders. Then what he does is, he passes an order on 21/2/2024. There, my lord, in a single page order,
Page number?
my lord, this we have filed it, this was produced by them also. And we have filed it along with an application for amendment where we have challenged 21/2/2024 during the pendency of the writ petition before your lordship.
21?
To 2024. Shall I?
It would be along with my statement of objection.
Correct.
Yes.
And along.
Last page in my statement of objection.
You have produced that.
Yes, sir.
Sorry.
Statement of objections by R2.
Even we have.
Yes, you are right.
My lord got it. 21
R4 it is perhaps,
R2.
R2.
21 to 2024.
ಎರಡು objection ಇದೆ ಇವ್ರದ್ದೇ.
It was filed on 31/7/2024.
R2 though.
It's also, my lord, we have produced it along with our application for amendment. Amendment is
Was
allowed.
there some direction that they should produce, give copy of this, something like that, vaguely I remember.
Your lordship said issued direction.
Ah.
Then they came up with this suddenly, my lord, with the
Correct,
one.
they produced it, na?
Yes, my lord. Your lordship said when it. My lord got the order.
Yes.
21. I'll just read that. I'm directed to refer to the Honorable Court order dated 14/8/2019.
One second, not that.
21.
Right, 21. 63. Ah,
21.
this is 31/3/21.
No, 21 to 24. This is the order. 21 to 2024. My lord, may I just quickly pass this on?
ಅಲ್ಲ,
ಅಲ್ಲ,
ಮತ್ತೆ
ಇದೆಲ್ಲ highlight ಎಲ್ಲ ಮಾಡಿದೀನಿ, ಅದಕ್ಕೆ ಅದು little reluctant to give.
ಕೊಡಿ. Anyway, you are a colorful person.
ಕೋರ್ಟ್ನವರೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. We will now accept it.
My lord got this order.
ಇಲ್ಲ, ಇದು ತಮಗ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ. ಇವರು ಧಾರವಾಡಕ್ಕೆ ಹೋಗ್ತಾರೆ.
ಹೌದು.
ಅಲ್ಲಿ ಹೋದಾಗ ಒಂದು 10 ಜನ 15 ಜನ ಎಲ್ಲ ಊಟ ತರ್ತಾರೆ.
ಹೌದು.
ಎಲ್ರೂ ಇವರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಕೊಡ್ತಾರೆ.
ಹೌದು.
He will have a repast
ಹೌದು.
of 20 different
ನಮ್ಮಲ್ಲಿ ಈ ಒಂದು ಈ ಬನದ ಹುಣ್ಣಿಮೆ ಅಂತ ಬರ್ತದೆ, ಅಲ್ಲಿ ಪಲ್ಯದ ಹಬ್ಬ ಅಂತ ಮಾಡ್ತಾರೆ.
ಗೊತ್ತಾಯ್ತು.
ಒಂದು 100 ಪಲ್ಯಗಳನ್ನು
ಹಂಗೆ ಇವರು
ಹಂಗೆ ಇವ್ರದ್ದು ಉತ್ತರ ಕರ್ನಾಟಕದಲ್ಲಿ. Yes.
So my lord, here I am directed, my lord's got it, my lord, 21 to 2024 order.
Yes.
My lord, I am directed.
I am directed to refer to
Yes, my lord.
Honorable
14
High Court order,
2019 and 25 passed in WP.
personal hearing.
Dated, your lordship may kindly mark, my lord, 15/1/2021.
Correct.
Regarding the above mentioned subject, and to say that during the personal hearing, dated so and so, you are advised to give written submission regarding furnishing of additional fees of ₹50 lakhs for extension of their IEM, dated so and so, or may obtain fresh distance certificate from state government. In this regard, you have not submitted any written.
ಅದೇನದು or obtain fresh distance certificate, ಅದೇನು in lieu of IEM ಅದು.
Andre, in fact, if I didn't want to do it or pay the extra, those 50, every year we'll have to pay that 50 lakhs if we have not completed the project within that, then every year we are supposed to pay 50 lakhs to them. So if you don't want, then you can probably apply for one more distance certificate, take one more IEM, because if there is nobody else, so there is no impediment. So in this regard, you have not submitted any written submission committed towards the extension of your IEM. Further, in regard to obtain this, my lord, we have disputed, we have already filed that no such order was passed and we were ready and willing. My lord, because if this was the case on 15/1/2021, my lord, he passes the order only on 21/2/2024 after 3 years. This, my lord, that order, after 3 years, my lord, he passes this order.
After the order of learned single judge.
Yes, no. After the order of learned.
That was in 2019.
19. So
14/8/2019, something you said. Yes.
14/8/2019. So my lord, he says on 15/1/2021, you are asked to pay this. We, my lord, we have said, but what he has said is not correct, my lord, because we have said that. And if that was correct, if your lordship says if 21 we had said no, he waits for 3 years and then passes this order. After 3 years. So my lord, then he says, so this is not, my lord, with regard to, he does not say that my IEM is derecognized. All that, my lord, he says is, if further obtain a fresh DC so and so, Nadi Halli, that is the respondent, their letter dated 1/1/22 submitted fresh DC at location number so and so, requested to take their factory on record as new sugar factory. In the absence of your submission commitment for extension of your IEM, this office accepts the BG of Ms. Nadahalli Ethanol and Allied Industries Limited and the proposed factory at so and so, Karnataka was taken on record as new sugar factory vide order dated so and so. Therefore, in view of the above, it's informed that the IEM of dated stands derecognized under the provisions of sugarcane control order as amended. So, my lord, here one, my lord, vide a detailed order, my lord, you are supposed to pass an order. He does not do that. And he does not say that I have not taken steps or on any of the violations of any of the provisions, he does not say. He only says that since you are
Not applied for,
we have, my lord, we said we are ready and willing, my lord. Why would we, my lord, fighting in the court, my lord? We would want that. We have said that we'll give. This is not correct, my lord. And otherwise, there was no, my lord, for us to keep fighting in this court for our IEM. So we have said that we will do it, but that has not been done. And
no, where have you applied for? You show that. He has given reason. He need not give that elaborate reason.
No, no,
He says you have not applied.
Lord, because we have said that in our made a statement in the amended, my lord, your lordship may see, we have filed amended writ also. Well, because since this order was passed during the pendency of the writ petition, we then amended the writ petition challenging this.
ಒಂದು ರೀಸನ್ ಕೊಟ್ಟಾರ ಅವರು ಆ ರೀಸನ್ ಸರಿ ಇಲ್ಲ ಅಂತ ತೋರಿಸ್ಬೇಕು ನೀವು.
Yes, what we have said is has 26B, the respondent number 2.
ಇಲ್ಲೊಂದು ಸ್ವಲ್ಪ ಇದೆಯಲ್ಲ.
If he says it was asked, if it was asked, we would have definitely given. So here, my lord, para 26.
But fact remains that you have not given.
Lord, this was not.
On facts, let us speak.
As on today, no, we are not. We are not.
What is your
So our
explanation?
thing is, if we were called upon, we would have given it. Para 26.
The question of furnishing arises only when you are called upon.
Yes, because my lord, my
What is
entire,
the,
my entire derecognition is in question. So my lord, he could have either, my lord, upheld his earlier order of derecognition, or if he had to do it, then he'll have to say that we will give you an extension provided you pay this amount. Unless, my lord, he tells us that this is that if we are willing to pay, we will give it, my lord. If he tells that, my lord, the entire thing is,
which rule speaks of this?
my lord,
Just
that
show
is,
that.
6, the sugarcane control order.
Amended order.
Yes.
Read. There is duty on him to call for. That you have to show. That duty may arise in the totality of the circumstance is one thing. But those circumstances, let us see the text of that rule,
Yes.
that paragraph of the order. And how courts have interpreted. It's not that for the first time it is coming before Justice
So,
Dixit
Lord,
and he is
this
seeing.
particular thing has not been done. Only with regard to automatic derecognition, my lord, the Honorable Supreme Court in Swami Samarth judgment have very clearly laid down that there can be no automatic derecognition and opportunity has to be given. So anyway, here that has not happened. The Kane Commissioner, which we have challenged before your lordships in the present writ petition, not there. The Kane Commissioner says there is an automatic derecognition, which is not correct. He had no jurisdiction and.
Because of Samartha judgment.
Yes, 3 things, my lord. Kane Commissioner could not have passed that order because 1, he does not have the jurisdiction. Second, in the teeth of the order passed by this honorable court, my lord, quashing the order of derecognition. Third, and since it was pending before the central government, he could not have gone into that issue and said that it is automatic. Fourth, my lord, is there is no automatic derecognition as per the judgment of the Honorable Supreme Court.
There should be specific order.
Yes, because they say what earlier they said was only if the amount is to be forfeited, then you have to be given an opportunity. And if you are able to explain as to why you could not do it, then the amount would be returned. So they, my lord, they felt that only for the amount you have to be heard. With regard to derecognition is by operation of law. My lord, that the Honorable Supreme Court said no. Even for this, it has to be heard. That I'll point out.
Other day, you have read that judgment.
Yes, I had pointed that out. Now, with regard to this, my lord, where now this is an issue where, my lord, the CDS my lord, when that extension and under the 2016 and then subsequently amended in 2018, where they have granted more time, 3 years, 5 years to start the commercial production and all that. So for each year, then they say that you have to pay the excess amount. And in Ojas and in Shiv Shakti also, they have said, if suppose the dispute is in the court, for that period, probably those years can be excluded and they can be asked to pay whatever.
While computing that period.
Computing that period. So that also issue was there.
Yes.
Lord, 6A says restriction on setting up of 2 sugar factories with a radius of 15 kilometers.
6A.
6A.
6A ಇಲ್ಲೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. Some 7 ಗೆ ಹೋಗ್ಬಿಟ್ಟಿವ ನಾವು. Amended, ಓದಿ ಒಂದ್ಸರಿ just. ಅದ್ರದ್ದೊಂದು amended literature ಕೊಡಿ. This is a 25 Ashada 1888 ಅಂತ ಏನೋ.
My lord, this along with
15
the
July
memo filed from
1960.
4/3/24, my lord, we have given these sugarcane control orders.
4324, you have given that. That is
Memo.
it's there at page 14.
Yes, page
Ah.
14 is 2010 and then the page 38 to 41 is 2016 amendment.
38, you are right. Six A.
6A.
The central government or any person authorized by it in this behalf may direct any producer or importer or recognized dealer to furnish such information. So and so, so and so. ಅದಂಗೆ apply ನಿಮ್ಗೆ help
Then
ಆಗ್ತದೆ.
my lord, 6B is with regard to requirement of filing the IEF, which your lordships are asking, my lord. So where they talk about when it should be filed and within what time the BG is to be given. This is, my lord, with that is in 6B. Then 6C is the time limit to implement the industrial entrepreneur memorandum. Then 6D, consequences of non-implementation of the provisions laid down in clause.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು? ಪೇಜ್ ನಂಬರ್?
This.
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. ನಿಮ್ಮ ಇದು ಪೇಜ್ ನಂಬರ್ ಏನು? ಹಿಂದಿ ಎಲ್ಲ ಇದು.
Well, if your lordship turns to page, page 24, page 24.
24. You are right.
Well, on the top, 6A,
6
restriction on setting up of.
A, B, C, D ಹಿಂಗೆಲ್ಲ ಇದೆಯಲ್ಲ?
ಹೌದು. Capital A, capital B and C. So, my lord,
Restriction,
A is with regard
restriction
to
on
this-
setting,
Beg your pardon?
restriction on
Setting up of sugar factories. So this, my lord, was that there should not be any unhealthy competition, and as your lordships, my lord, wanted if whether both of us can coexist, my lord, but there is not sufficient cane here in this Bijapur side area.
Yes.
Then 6B, ma'am,
B is placement of firm.
requirement for filing the industrial entrepreneur memorandum.
6B, you are right.
Then 6C,
Time limit.
yes, ma'am. Like they say, stipulated time for taking effective steps shall be 2 years. Commercial production shall commence within 4 years with effect. This, my lord, they kept on increasing with 2016, 2018. This time limit has been extended.
They either power to extend.
Yes, ma'am. They have, my lord, the power, my lord, looking at the grievances, my lord, they have done that, my lord, from 4 years. they've
That
made-
proviso gives a power to extend.
Yes. Provided that the chief director of so and so, on the recommendation of the concerned state government may give extension of 1 year, not exceeding 6 months at a time, the implementing of so and so.
So
Then-
6 months plus 6 months, 1 year ಕೊಡಬಹುದು.
ಆಮೇಲೆ but ಅದನ್ನ ಈ 4 ವರ್ಷ ಇದ್ದಿದ್ದು then they made it 5 years.
ಎಲ್ಲಿ?
Then my lord 6D, consequences of non-implementation of the provision of laid down in clauses 6B and C.
Shall be forfeited,
Yes,
forfeiture.
forfeit. So in 2016, they say that it stands derecognized if we don't implement it within that time, which my lord has come up for interpretation. So now, my lord, my case is the impugned order passed by the Kane Commissioner, my lord, one, my lord, he could not have passed that. I'll not repeat that, my lord. Second, now since we have challenged this order.
You have repeated and I said I will not repeat.
Yeah, ಅದು ಒಂದೇ
Anyway,
ಹೇಳಿ-
all right.
ಅಲ್ಲ ಅದು ಫುಲ್ ಹೇಳೋದಿಲ್ಲ ಅಂತ 4 ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಅದೊಂದೇ ಆರ್ಡರ್ ಹೇಳ್ಬಿಟ್ಟು.
All right.
So, my lord, and then this CDS order, my lord, now he if we are willing to pay, my lord, he says it can be considered. My lord, we are willing to.
Yes.
My lord, now the only question, my lord, what your lordship asked is, my lord, if in your lordship may see this date also, my lord, what we have said in our amended writ petition that this was not done, my lord, we have made that averment in our amended writ petition in clause 26. See, that it is further submitted that the minutes of the meeting dated 15/1/2021 was never issued to the petitioner, nor any notice for payment of 50 lakhs per annum after completion of 7 years, as mentioned in the minutes of meeting submitted to this honorable court was provided to the petitioner. The said minutes was brought to the notice of the petitioner in the above proceeding. As a matter of fact, it can be noted that the meeting was held on 15/1/21. However, the impugned order was passed only after filing of the above petition. That too, without any explanation for the delay.
Yes.
So, my lord, we were, my lord, willing to.
That order is 24 February 2024,
2020.
24.
And this order.
Learned single judge's order is 14/8/2019.
90. Though it was 6 weeks, my lord, he has taken now so much time in passing the order.
His weeks will be different. May not be calendar weeks. Yes.
So, my lord, like the Jupiter's flame.
Your learned AST is also smiling now. Yes.
So, my lord, this, my lord, order, my lord, could not have been passed. And, my lord, now, and even, my lord, we have also produced certain judgments, my lord, which paraprotocol, I'll not bother your lordship for that. My lord, the division bench where, my lord, learned senior, my lord, I had the good fortune, my lord, to have him on my side in that matter, my lord.
In
But
that
here now
matter,
he's
it
on the
was
other
his
side.
argument, Mr.
Now he's
Holla's
on-
argument only.
Now he's on the other side. So
Anyway.
there, my lord, also, my lord,
But you can't go by that impression because ಅವ್ರದ್ದು ಅಕ್ಷಯ ಪಾತ್ರೆ ಇರ್ತದೆ. ಒಂದು ಎಂತದೋ ಒಂದು ಹೊಸ ತೆಗೆದೇ ಬಿಡ್ತಾರೆ.
So, my lord,
Anyway.
what the honorable division bench says, if suppose the IEM, my lord, if it has been quashed, that it would be in currency. It's noticeable at page 107, internal page 19 of the honorable division bench passed by this honorable court.
ಅದೆಲ್ಲಿದೆ?
That's memo, it has been filed along with the memo of citations.
Where Mr. Holla had argued that matter, not that matter.
Not I had argued this matter. He was also there. He appeared for one of them and I appeared for one of them. But both were in tandem, my lord, arguing this. Straight only to pay
Page number?
107, internal page 19.
Page para 15,
Para 15.
just.
It's noticeable that the order of derecognition dated so and so was set aside by the order dated 10/20. This would imply that the IM granted in favor of so and so continued to be in currency.
That was in which case it was?
My lord, this was in regard to another sugar factory.
Another
there,
sugar
that
factory.
IM, my lord, what had
Okay.
happened in similar thing, my lord, where IM stood derecognized and and there again the contention was that automatic and all these issues were there. So, my lord, all that I'm trying to say, my lord, draw support from this order is that it
Once
is
it
in
is
currency
derecognized, once it is derecognized
and it has been state
and
of,
that has been stayed or set aside,
then it is in
it is
currency.
deemed to be in currency.
Currency.
For
That's
that
all.
proposition you are
Yes.
saying.
So if that is there, then 50 kilometer range, my lord, will apply to him and he cannot be permitted to set up because.
Because
I am
that was in already in operation.
Yes, that's all. That's all is my case. That Swami Samarth, my lord, we have produced it, that is there. That is para 44 of that judgment.
Let
that
us
there cannot
see.
be any automatic.
Let us see, Swami
Yes,
Samarth.
your lordship may kindly see that. Lord, the para 56, that is ink page 58 and page 37 of the. Can I just read that?
Page
page 58, my lord, in page 58, this is Swami Samat's judgment, para 56. 38, I'm sorry, page 38
38.
and para 56.
Existing sugar factory.
Yes, no, existing, I had argued that IM stands lapsed as the appellant had failed to set up a factory and to commence the commercial production. However, we are unable to agree with such interpretation. The clauses 6C to as applicable on 10/11/2000 as well as on 24/8/2016 and 12/8/2018 contemplate that IM shall stand derecognized and the performance guarantee shall be forfeited. The performance guarantee is to be forfeited in terms of clause 6D after giving the reasonable opportunity of being heard. We find that the twin conditions have to be fulfilled. One, failure to set up a plan and to commence production, and then the forfeiture of the performance guarantee. Second will not arise unless the first is satisfied, and the second step cannot be undertaken without complying with an opportunity of personal hearing in terms of clause 6D of the control order. Unless the performance guarantee is forfeited, there is no lapsing of IM. Thus, unless the necessary consequences of derecognition of IM are undertaken, there is no automatic lapsing of IM. Such is the language in the subsequent amended control orders as well. The appellant had furnished a performance bank guarantee of ₹1 crore. However, no steps were taken. But I'll just stop at this one. So it is only to say that there is no automatic derecognition.
Because of the language of the
Yes,
control order.
and it is not that you have to be heard only with regard to forfeiture. It is also with regard to the first one, with regard to derecognition. That's all is my case. And our other also contention is that their IM and all this, the certain conditions which they have to follow, they have not, that the learned senior counsel could probably, justify that you have to, within 1 month, you're supposed to.
Our argument like.
That's all. That's all is my case.
No, suppose if he does not raise that point at all.
My lord, the sugarcane control order which my learned friend produced is incomplete.
Yes, it is.
Please come to my lord. Please come to objections filed by the second respondent dated
Central government.
19th of July 2024. One the crucial one anna ಹಾಕೇ ಇಲ್ಲ. ತೋರಿಸಿ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ನೀವು ತೋರ್ಸೋದ ತೋರಿಸಿ ಇಲ್ಲ ನಾನು ತೋರಿಸ್ಬಿಡ್ತೀನಿ. July 2024 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
19th July 2024
ಅಂತ ನಮಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಮಗೆ ಇಲ್ಲಿ
update.
ಸಿಕ್ತಾ? My lords may come to my lord page 22 of this document. 22.
You are right.
My lord sees clause 2 ನೋಡಿ.
Time limit.
This is my lord amendment to 6C. ತಾವು ಮೇಲ್ಗಡೆ clause 2 ಬನ್ನಿ.
This is 30th December 2020.
Correct. ಅದು ಇದ್ರೊಳಗೆ ಮಿಸ್ಸಿಂಗ್ ಇದೆ.
But ಇದು retrospective or prospective?
My lord, it is prospective, retrospective ಅಲ್ಲ. It applies to everybody, including him.
His challenge was 2000.
I'll tell your lordships. What happens is, please come, my lord. I'll tell your lordships why, my lord, this is relevant. Please come to my lord. Time limit specified in subclause. My lord, clause 1 says within 5 years you are required to do it. Please come to paragraph 2.
This benefits him.
Paragraph 2.
This benefits him. This notification benefits the petitioner.
Anyway, let us.
Provided
you are the author of that.
Adರಲ್ಲಿ, my lord, this notification was issued to amend 6C to give an extra grace period. So I will read that.
Other than what was
Originally,
2 years it was.
yes, originally it was 2 years for effective steps,
Correct.
4 years for production.
Okay.
We amended and made the effective steps 3 years and production 5 years. It was 8 years.
That will inure to his benefit.
No, after 8 years, now we said if it was due to unforeseen circumstance, we can give extension of 1 more year.
1 more year.
Yes, but there were some conditions. Now, question is whether those conditions were not satisfied.
Complied with that.
Yes, my lord, let me demonstrate that. My lord, if your lordship would now see that page 22, item 2, in sugarcane control order for clause 6C, the following shall be substituted.
It's a substitution, so it is retrospective.
Yes, the time limit to implement industrial entrepreneur memorandum, which is IM, the stipulated time for taking effective steps as specified in explanation 4 to clause 6A shall be 3 years, and the commercial production of sugar shall commence within 5 years from the date of filing of the IEM with the central government under subclause 1 of 6B, failing which the industrial IEM shall stand derecognized as provided under subclause 2 thereof, and the performance guarantee furnished thereunder shall be forfeited.
Rest of the things remain as their.
The next para is very critical. The time limit in subclause 1 may be extended in the following manner, namely A, where the delay is due to any unforeseen circumstances beyond the control of the person concerned, such as natural calamities, including drought or non-availability of sugarcane raw material during off-season in the year in which the stipulated period terminates, or non-financing of sugar sectors, or delay in getting necessary approval from the state government, or due to any court case relating to land use.
Port is also taken as a disaster.
Yeah. Environment or under such reasons that may have arisen within 5 years from the date of filing of the IEM, the Chief Director Sugar, Department of Food and Public Distribution, Ministry of Consumer Affairs, Food and Public Distribution may, after expiry of 5 years period in subclause 1, extend the period stipulated in clause 1 to a further period of 2 years, not exceeding more than a year at a time, provided that such extension for taking effective steps or the commencement of commercial production of sugar may be granted in consultation with state government concerned and the Department of Legal Affairs, Ministry of Law and Justice, if considered necessary. Provided that in case where the commercial production of sugar does not commence within such period, the bank guarantee furnished under clause 2 of 6B. Yes, and then clause B is most important. In case where such a delay arising due to any unforeseen circumstances or delay in getting necessary approval from the state government or court case relating to land use, environment, or such other reason continues beyond the period extended under item A, the Chief Director Sugar, Department of so-and-so may grant extension of further period as he deems fit, not exceeding more than a year at a time. But this is important. Subject to furnishing a bank guarantee of rupees 50 lakh for each year for which the extension is sought, which shall be in addition to the bank guarantee furnished under subclause 2 of clause B.
1 crore.
1 crore. Yes.
So now, my lord, so after this, my lord, after the learned single judge passed an order in 2019, Lord, after the learned single judge directed us to reconsider, we called for a meeting on 15/1/2021. Yes, I have produced a copy of the file note. I produced a copy of the file note maintained by the second respondent, which is available at page 15 in the statement of objection.
1/5.
1/5. It says note number 42, letter issued on so-and-so. Page number 15, 1/5.
You are right.
Subject, personal hearing held on 15/1/2021 in the Chamber of Chief Director Sugar regarding court order, regarding court order dated 14/8/2019 in WP number so-and-so filed by so-and-so, so-and-so. It may be recalled that Messer so-and-so was granted IEM dated 13/8/2010 for setting up new sugar mill at so-and-so. The proposed mill was taken on record as new sugar factory, vide order dated 26/4/2011. It was observed that they have not at all taken effective steps up to 12/8/2015, nor commenced commercial production within stipulated time up to 12/8/2017, maximum permissible time 7 years as per clause 6A. After due consideration, IEM dated so-and-so has been derecognized and confiscated bank guarantee, vide orders dated so-and-so. Mr. So-and-so had filed a writ petition in so-and-so before the Honorable High Court of Karnataka, Bengaluru, prayed to stay so-and-so, so-and-so. The Honorable High Court of Karnataka at Bengaluru, order dated so-and-so reproduced. The Honorable High Court has passed an order dated so-and-so. Then it says, in view of the submission made and taking into account the fact that while passing the impugned order dated 2012/2018, the effect and impact of Sugar Control Amendment 2016 has not been taken into account by the competent authority, the impugned order is hereby quashed. My lord, this my learned friend has already read. The effective part, my lord, is at page 17. Page 17, para 6. During the, beginning with the words, during the hearing. During the hearing at the outset of discussions, undersigned apprised the Chief Director Sugar about the matter in brief. It was apprised that they were required to complete mandatory effective steps by 12/8/2013 and commence commercial production by 12/8/2015. However, they could not commence commercial production by 12/8/2017, maximum permissible time 7 years. Accordingly, video order dated so-and-so, the IEM dated so-and-so for setting up new sugar factory at so-and-so was derecognized and bank guarantee of 1 crore submitted by so-and-so. Chief Director Sugar asked the representative, my lord, this is critical, of Messrs. SSPL, which is the petitioner, to substantiate the request in this matter, if any, as per new provisions of Sugar Control Order 1966, as amended with a notification dated 30/12/2020, which I just read out to your lordship,
Yes.
and amended dated 24/8/2016. He requested the chair for issuance of NOC to the department for promotion of industry and internal trade for issuing fresh IM in the same company name and location as he has purchased land at the same location. Chief Director Sugar advised him that there is no such provision in the Sugar Control Order as amended with a notification dated so and so. However, this case can be considered under provision of 6C, subclause 2A, B and C as requiring submission of bank guarantee of rupees 50 lakhs per annum from completion of 7 years from the date of IM. If agree, you may submit written submissions today only or may obtain fresh distance certificate from state government and to be applied for fresh IEM at location. Mr. SSPL did not give written submission assured by him during personal hearing on 15/1/2021 as per new provision of Sugar Control Order amended vide dated 30/12/2020. In compliance of court order 14/2029, draft picking order is attached for approval. So there was a communication which was prepared. It was placed for approval. And then, my lord, what is critical is if your lordship would now turn to
No,
the-
whether this was approved,
my lord,
you had
my-
sought for approval.
my oral instructions are, Lord, as on today, I do not have any written proof of that. But I believe after approval, the impugned communication of 2024 was sent. But there is one document, my lord, which I would like to bring to your lordship's notice, is at page 14. Page 14 is the
Who should approve this under the normative
the
procedure?
CDS himself.
Who should approve this?
The Chief Director Sugar.
Yes.
The office note is put up.
Put up.
Office note is put up, so he should approve it. I believe the particular incumbent retired subsequently. The new incumbent, I'm told, my lord, I've sought for furnishing written evidence, but they say that after it was approved, only the 2024 communication was sent.
Communication was sent to petitioner.
Petitioner, which is challenged now.
No, that was not sent. You shared it in the open court.
No, no.
Your
Order was shared in the open
colleague shared it in the open court. Then he took leave of the court to amend the petition.
this-
All right, just show how it was sent.
Other proof is there?
Show that how it was sent.
Yes, madam. I'll secure that. As on today, I don't have.
ತೋರಿಸ್ಬೇಕಾಗತ್ತೆ.
It was-
Approval on ತೋರಿಸ್ಬೇಕು. How it was, what was the mode you adopted to send it?
Only one further document is page 14. Page 14, a director named Dilip Desai, representing the petitioner, attended the hearing. So my respectful submission would be, he was in the know of the
No,
proceedings.
that's insufficient. You have seen what the apex court has said.
True. Not the- It was, it was not handled in the most ideal way. Not, I can submit that.
You're more than fair, as you have been always. ಅದು ಒಂದು ಎರಡು ಡೇಟ್ ಅನ್ನು ಕೊಡಿ.
Here I will first.
Mr. Bhalla will ask for that also, because that's very important. He has challenged that itself.
Whether this communication was sent. to-
Because apex court said, even our Justice Ravindran, there is one Aditya, there is one judgment. What is meant by approval? So Justice Ravindran said of this court, Honorable Justice Ravindran, as his lordship then was, approval means a formal endorsement by the so-called designated approving authority to the draft. Till approval is granted, it continues to be draft only, incapable of any legal consequences. There is such a judgment of apex court, which Surendra Malik refers in his Supreme Court on words and phrases. Just take out that. There is such a judgment holding that. What is meant by? He refers to Ramnath Iyer's law lexicon and quotes that judgment. That is referred in that Supreme Court judgment. Incidentally, it was again a sugar factory matter only. Just look into. Okay, my memory may not be correct sometimes. Just look into. No, just whatever I have read, in Surendra Malik's, it is there. That judgment is there. Learned ASG argued the matter for some time, vociferously. Full stop. when asked as to whether the subject order dated 21/1/2021 had gained approval at the hands of the jurisdictional authority, and whether a copy of the said order was marked to the petitioner by traditionally known modes of communication have to be
Traditional loan, RPD.
furnished to the court, First, even the original file concerning the same needs to be exhibited for perusal of the court. First off, in view of, since these factors are very relevant to the adjudication of the petition at hand, such a requirement is stated. First, call this matter on. Call this matter when judge of this court sits single. First off, the information sought for shall be kept ready for being furnished to the court whenever court holds the proceedings.
I think what you said 18/1, it should be 15/1 order date.
15/1,
15/1/2020.
15/1/2020.
It is 18/1. Your lordship dictated 18/1, probably it's 15/1. Huh? 15/1.
Is it?
Is 15/1 alone. 15/1.
15/1.
That order which you referred to, that approval.
File note, that file.
Come to page 18. They say 21/1/21.
That's probably side. Please, I mean.
ಅಲ್ಲ ಎರಡನ್ನು ಡೇಟ್ ಹಾಕಮ್ಮ 15/1/2021 and 21/1/2020. ಅಲ್ಲ Mr. Halla, let it come.
ಆಯ್ತು ಯಾಕಂದ್ರೆ what has happened is 2010 ಇಂದ 2024 ತನಕ 14 ವರ್ಷ he wants to block that my lord what the additional director my lord who came said this kind of a thing my lord cannot be permitted. Nothing has been done. What they do is they block my lord the others from coming. They will not do anything. Everything my lord is a standstill, and I'll point out all that. And I'll be able to satisfy your lordships. Even my lord, if there is no approval, it does not matter. Because the rule my lord is very very relevant. I'll point out all that. Anyway, I don't want to know. Since your lordships have called for it, your lordships may have a look at it. But then my lord, I'll be
Mostly
able
ಅದು ಬೇಕಾಗ್ಬೋದು.
ಇರ್ಲಿ.
Otherwise, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಾ? ಇಂಥದ್ದು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಅಲ್ಲಿ ಒಂದು ಡ್ರಾದಾಗ ಇಟ್ಕೊಂಡು
ಗೊತ್ತಾಯ್ತು.
ಕೂತ್ಕೊಂಡು.
ಅಲ್ಲ.
And Apex Court has noted this.
No, I agree.
I am not making ex cathedra statement.
No, my lord, I agree with your
Apex
lordships.
Court has said this.
Absolutely, there are. I can give you your lordships judgments also. But then, rule my lord, he is bound to my lord pay that 50 lakhs, which he has not done every year. ಅದು ಆಯ್ತು ಅದನ್ನೆಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ತಮಗೆ.
Your lordship.
ಅಲ್ಲ ಅದು ಆ ಕ್ವಶನ್ ಹೇಳೋದು ಯಾವಾಗ ಅಂದ್ರೆ ಈ ರೂಲ್ ನಲ್ಲಿ ಒಂದು ಇಂಟಿಮೇಷನ್ ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ ಅದನ್ನ ಅವ್ರು ಇಟ್ಕೊಂಡು ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ.
No, my lord, what happens is he is bound by the rule. It is my lord whether he is communicated the rule or rule is my lord gazetted. He knows the rule. ಆಯ್ತು ನಾನು ಅದನ್ನ ಹೇಳ್ತೀನಿ. I'll give you a lordships my lord. It's
So
a
there need not be demand at all. He should go with the check.
correct.
A deal.
Anyway, my lord, I'll point out.
Let
all
us.
that. Anyway,
Your lordship,
Grateful
I
to your
have
lordship.
one question, whether the sugarcane control orders are retrospective.
ಎಲ್ಲಿಂದ?
Lord, that the Supreme Court in Coexistence and in Swami Samartha said they are retrospective.
In fact,
Which the learned ASD said that it will inure to his benefit.
Rightly said.
Yes, rightly said. That has been held to be retrospective.
in fact, ಸ್ವಾಮಿ ಸಮರ್ಥಲ್ಲಿ ತೋರಿಸ್ತೀನಿ 6 ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಇದೆಲ್ಲ ನೋಡ್ತೀನಿ ತೋರಿಸ್.
But one thing, Mr. Halla, much of law in this country has marched because of Swami's cases, Swamiji's case, including Keshavananda
Keshavananda
Bharati,
Bharati, absolutely,
Shraddhananda,
absolutely.
Swami Samartha,
ಹೌದು.
so many cases.
Yes.
We always believe in God, my lord. Many a time we forget the men. ಅಲ್ಲೇ ಆಗಿರೋರು men and women. ಅಲ್ಲೇ ಅವ್ರದ್ದು. Only we think of God. Correct. Both are needed. Ultimately, my lord, after thinking about the God, we must also look at the plight. And that's why, my lord, your lordships are here. Temple of Justice, Adu temple of God. This is temple of justice.
Yes. Not other jati haki. Yes.
It's
Respondent number 1 and 2.
3, I'm told, my lord, the process has to be, I will do that within a week.
Process of steps. You wanted a review of this
Review, I have sought for review.
The mail,
Lots
friend
of
Ajar
kindly-
mail ಇಲ್ಲ ಏನು? Because you wanted action against the mayor also.
Yes, my lord, the lordship's direction
And the
number,
authority is someone else.
someone else, my lord. That was only, so we requested for modification of,
But having complied with order,
one is complied, my lord. We have initiated private complaint.
Ah.
Similar action will also have to be initiated as against the mayor, my lord. Because he is also a councillor first. Disciplinary action as against mayor may not be possible because of
time gap.
even jural relationship, whether exists.
Precedent, huh?
Yes.
Padi. He says the authority is the government. Government is the authority.
Mayor should
Mayor should
brought-
have done
brought
that.
to the reference to the government.
All right. Suppose mayor is dead. You mean to say obligation also dies? Mayor is an office. No office lives in vacuum. That's the. Therefore, mayor has retired, a term has expired, mayor is short dead. How that is going to discharge the legal obligation? But when office objection, court fee and state to court fee kodbekana? State court fee kodeka? I don't think like that. What is the legal point? State should pay the court fee.
Stamp duty, there is an exemption. or court
Stamp
fees-
duty, that's all, right?
Court fees.
We have not.
Court fee has to.
I will ensure that. I'll ensure it.
Sorry.
Court fee could come. No, no. But generally in England, no court fee, no stamp duty, no registration fee was payable by the crown and his officers. Anyway, let us see.
Yes.
Because in ours, other day I've seen that 1966 Supreme Court, the
Yes.
5 judgment decision,
Remembrancer.
Yes.
a legal remembrancer, Calcutta versus Calcutta City Corporation. Law applies to state unless law itself exempts it from application. It's reversed in the apex court judgment of 1963, which was reversed. Law does not apply to the state. That has been reversed now.
Yes.
Just look in.
Where the authority of the court used to derive from the crown itself. The judge sits as a delegate of, the crown sits as a delegate of God.
God.
Judge sits as a delegate of the crown. And
Correct.
therefore, the crown in its cause does not need to pay itself.
That was the principle.
We have a constitutional separation of powers.
Correct, correct, correct. That's true. Nobody sits under the shadow of anybody. They're all independent authorities.
Be you ever so
Notwithstanding
high.
the,
Be you ever so high, the law is still above you.
correct. That's true. Yes.
For the petitioner, review petitioner.
Ah,
Earlier day, LRs were brought on record in the abatement like the song.
ah,
Number 1 for condemnation of delay is required to be.
Padi.
I had come before this court in the form of 2 IAs, but to recall the order and for imprisonment.
ಅದೇನೋ ಮೀಡಿಯೇಟ್ ಸೆಂಟರ್ಗೆ ರೆಫರ್ ಆಗಿತ್ತಲ್ಲ ಏನಾಯ್ತು?
No, it failed.
Failed. Failure report is filed. All right.
This honorable court directed me on 2/3/2023 that I spoke in Shivdev Singh's judgment.
Ah.
Review is the only option for me. I was given liberty. Therefore, I have filed. In the meantime, there is a delay of about 841 days. My IA was pending at that time.
What is the, this petition seek review of which order?
of the order passed by this Honorable Court, 17/12/2018. The Lena Swami, suppression of the title dispute itself was not made before this honor. It was totally suppressed. During the pendency of proceedings.
ವಯಸ್ಸಿತ್ತ
During the pendency of proceedings under section 30 of LAC Act, only few of the petitioners in this writ petition came before the trial court and filed application under the 18. And against that order, they came before this honorable court, and which a wrong judgment was quoted before this court, in which to allow this petition, Swami, what I am seeking review, in this, the petition sought for to be allowed was by relying on a citation made in WP number 554851. In that, there was no title dispute pending.
that makes all the difference.
And KDB, in the statement of objection, only one submission.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡೋಣ ಮೊದ್ಲ.
I will.
KDB is the beneficiary. They are not been heard before the LAC court. On that ground, my lord, this court has remanded. Nothing has been discussed by the.
ಆ ರಿಮ್ಯಾಂಡ್ ನಲ್ಲಿ ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡಿಬಿಡ್ರಿ.
Milord, one niche, why they are not entitled, I'll make, permit me for 1 minute, Milord.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡೋದು ಬೇಡವಾ?
Condonation of delay, they were having the knowledge of the entire proceedings. Therefore, I am having objections to that also. If your lordship, Milord, this is an indirect way of approaching into the section 18 reference.
ಮೆರಿಟ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡೋಣ. ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡೋದು ಬೇಡ ಅಂದ್ರೆ ಹೆಂಗೆ? ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಲ್ಲ ಅಲೋ ಮಾಡಿದ್ದೇವೆ ನಾವು.
841 days.
In 2 of my judgments, I have allowed your application where delay was more than 900 days. You want that copy to be placed here? Okay.
I do fully admit, Milord. I bow down to your lordship.
This statement.
ಆಮೇಲೆ ಮೇಲೆ ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
Merit mail, Milord. Yes, Milord.
Statement of objections
ಅಲ್ಲ,
clearly admits pendency of earlier petition.
why can't you learn advocacy? Yes. ಬರ್ಕೊಳ್ಳಿ. Review of judgment whereby WP was disposed of is sought for. Full stop. ಮೂರ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ?
ಇಲ್ಲ. Delay mail ಒಂದೇ application ಇರುವ.
An application in IA number 1 of 2023 supported by a verifying affidavit is filed seeking condonation of delay of 841 days in presenting the review, in presenting the review petition. First off, admittedly, the review petitioners, Obrena, petitioners were not parties eo nomine to the judgment whereby WP was disposed of. First off, ordinarily, in such circumstances, delay is viewed a bit leniently than otherwise. First off, if delay is condoned, no prejudice would be caused to anyone. And if not condoned, the review petitioner may go back heavy-heartedly, which is not a good thing to happen in judicial process. First off, true it is that delay is bit longer, and therefore, one who seeks condonation of longer delay has to pay or present some books to the Advocates Association Library. First off, learned counsel for the petitioner in appreciable fairness agrees with this. First off, next part, in the above circumstances, the subject application having been favored, delay stands condoned so that review petition can be heard on merits. First, of course, this is subject to the condition that the review petitioners shall present to the Bar Association Library. ಯಾವ ಪುಸ್ತಕ ಕೊಡ್ತೀರಿ ಹೇಳಿ? ಯಾವ್ದಾರ ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಹೇಳಿ, ಉತ್ಕೃಷ್ಟವಾದಂತ ಒಂದು ಪುಸ್ತಕ ಹೇಳಿ, ಯಾರು ಒಬ್ರು ಹೇಳಿ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ 1000 ಕಾಪೀಸ್ ಇದಾವ ಅಲ್ಲಿ, ಬಿಡಿ, ಬೇರೆ ಹೇಳಿ. ಯಾವ್ದದು? ಹಾ, Pollock and Mullah's Contract Act and Specific Relief Act. Correct. one book of Pollock and Mullah and law, latest edition to the library within 10 days. Full stop.
1 week.
All right, within, we are giving it in 10 days, but anytime post this matter, immediately after the presentation is made. All right.
Milord, in my matter, milord,
ನಿಮ್ದು ಒಂದು WP ಇದೆ.
ನಂದೊಂದು WP ಇದೆ, ಅದರಲ್ಲಿ ಪ್ರೋಸೆಸ್ 3 ದಿನ ಡಿಲೇ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಕಳ್ಸಿಲ್ಲ ಅವರು.
I'm appearing on behalf of YK and Sharma, please, madam.
YK and
Interim order needs to be extended, please.
is
ನಂದ್ರಲ್ಲಿ process ಹೋಗಿದೆ.
appears for 9829D. First law. In that case, in other case, another interim order run ಆಗೋದಿಲ್ಲ.
619.
Interim order to continue. All right, in RP interim order to continue. See, next date as a panel counsel, learned senior panel counsel, Naik said that there is some sense. At the most, you can be heard there also. So that everybody will be heard and orders will be passed. An injustice act. Nothing to lose. Anyway, ಇದು ಪಟ್ಕೊಂಡು ಬರೀ ನೀವು.
Milord, in my case, milord, R19 ಗೆ ಪ್ರೋಸೆಸ್ ಕಟ್ಟೋದು ಒಂದು 3 days ಡಿಲೇ ಆಗಿದೆ, ಕಳ್ಸಿಲ್ಲ ಅವರಲ್ಲಿ.
ನೋಡಿ, in a companion case, the delay, a short delay brooked in taking steps is condoned. Therefore, registry to send the process immediately.
One submission, madam.
Ah.
WP 8196, I filed an application, madam. If this institution kindly direct the officer tag this.
ಎದಕ್ಕೆ ಅದು application?
ಇದರಲ್ಲಿ milord,
Reassess because survey number 159 is concerned, they both.
ಏನ್
claimants are-
application ಯಾವ್ದಕ್ಕೆ ಅಂತ ಕೇಳಿದೆ, ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು.
Stick the repetition only in respect of survey number 157. The rival claimants are there, my lord.
ಬೇರೆದು ಸಂಬಂಧ ಇಲ್ಲ ಅಂತನಾ?
Therefore.
Is it true?
It can't be.
Specific order ಆಗಿದೆ.
ಏನಂತ?
ಅದರಲ್ಲಿ ಒಂದು your lordship have passed an order.
159, and 159 both are there.
Both
In
are
fact, 159, I am,
ಹಂಗಾಗಿ ಜೊತೆಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಜೊತೆಗೆ I have filed an application.
Registry to post application filed by
Venkat Reddy CM.
respondent ಹೇಳ್ರಿ, ಹೆಸರು ತಗೊಂಡು ನಾವೇನ್ ಮಾಡಿ.
It's in that repetition, my lord.
repetition.
8196 of 2007.
WP 8196 of.
Call these matters along with the petition number so and so, in which application is stated to have been filed. All
Request, my lord, in my writ petition, interim order to be continued.
right, entry model ಎಲ್ಲಿದೆ ಅಲ್ಲಿ continue ಮಾಡಿ.
My writ petition also it's there.
Wherever it is there.
Much.
ಒಂದೇನು ಅಂದ್ರೆ ಈ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಮಾಲ್ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಇಂಥದ್ದೆಲ್ಲ ನಾವು ಬಹಳ ಇದ್ರ ಮೇಲೆ ನಿಂತ್ಕೋಬಾರ್ದು, ಒಂದು ಸ್ವಲ್ಪ ಮ್ಯಾಗ್ನಾನಿಮಿಟಿ ತೋರಿಸ್ಬೇಕು. ಬಟ್ ದೇರ್ ಮೇ ಬಿ ಕೇಸಸ್ ವೇರ್ ಡಿಸ್ಪೈಟ್ ನಾಲೆಜ್ ಸ್ಟಿಲ್ ದೇ ವಿಲ್ ಲೈ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಅಂತ ಹೊತ್ತಿನಲ್ಲಿ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
Much.
ನೆಕ್ಸ್ಟ್ ಶಿವಕುಮಾರ್ ಏನಿದೆ?
Mortgage property was brought for sale
ವಾಸ್ ಬ್ರಾಟ್ ಟು
under the provisions of the Retroactive Act.
Ah.
A criminal petition is also filed. I have filed an application now that whatever amount that the valuation report is.
ಇದು ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಬಂದಿದೆ? ಇದು GM ಮುಂದೆನ ಬರುತ್ತಾ? ಓಕೆ, ನಾವು GMಗೂ ಇದ್ದೇವೆ ನಾವು.
2,87,83,000. 6 months I'll continue. Permit me to continue.
My lord, if I may submit, the property was already sold. The auction purchaser paid the entire amount. Sale certificate is also issued.
ಅವ್ನು ಪಾರ್ಟಿ ಮಾಡಿರಿ ನಾವು
ನಾನು auction
ಮಾಡಿಲ್ಲ.
purchase ಅನ್ನ ಮಾಡಿ.
ಮಾಡಿಬಿಡಿ.
Yes, because
ಅವ್ರು
he's
party
paid the
ಮಾಡಿ.
entire amount.
ನೋಡಿ, ಈಗ ಪೊಸಿಷನ್ ಕೊಟ್ಟಾಗಿದೇನೋ ಅವ್ರಿಗೆ.
My lord, section 14 and we have applied before the magistrate. That is pending.
ನಿಮ್ಗೇನು ಆಫ್ಟರ್ ಆಲ್ ಯು ವಾಂಟ್
My
ಮನಿ,
lord, other than.
ಯು ಆರ್
this-
ಬ್ಯಾಂಕ್,
Please, my lord,
ಎನಿಥಿಂಗ್ ಮೋರ್ ದೆನ್ ಬ್ಯಾಂಕ್ ಮನಿ ಯು ನೀಡ್.
my lord, my only submission is, other than the sale amount, I still have to recover approximately 15 crores.
ಎಷ್ಟಿದೆ ಅಷ್ಟು ಕೊಡ್ಬೇಕು.
15 crores is with regard to the other respondents. What happened is this, madam.
ನೀವಿಲ್ವಾ ಅದರಲ್ಲಿ?
ನಾನು ಬಾರಿ ಗ್ಯಾರಂಟಿ.
ಇನ್ನೇನ್ ಬೇಕು?
My lord, the guarantee is for the entire.
Mortgage document of this aged lady, one of the persons who was an auditor of her, he somehow managed to get the property.
ನೋಡ್ರಿ, ಅದನ್ನ ಇಲ್ಲಿ ರಿಟ್ ಕೋರ್ಟ್ನ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ ಬರ್ತದಾ? ಇಫ್ ಯು ಆರ್ ಎ ಗ್ಯಾರಂಟರ್, ಯು ಆರ್ ಮೋಸ್ಟ್ ಪ್ಯಾಂಪರ್ಡ್ ಡೆಟರ್.
Only with regard to mortgage property, I am asking for a division. I want to go out of that particular form.
ಒಂದು ಇವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ
ಮಾಡಿದ್ವಿ,
ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದೀರಿ. ಕನಿಷ್ಕಾ ನಾಗೇಶ್ ಅಂತ ನೋಟಿಸ್ ಆರ್ಡರ್
ನೋಡಿ, ಇಶ್ಯೂ ನೋಟಿಸ್, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರಿ? ಹಿ ಈಸ್ ನೆಸರಿ ಪಾರ್ಟಿ. The coordinate bench order dated so and so is recalled. In as much as the auction buyer is a proper party, if not a necessary party, in the light of decision of Apex Court in Rajia Begum versus so and so, AR 1958 Supreme Court, so and so, so and so. Full stop. Issue emergent notice to the said respondent. Correct. Stay there, niga.
Stay of auction, sale.
Stay of auction. ಎಷ್ಟು ಅಮೌಂಟ್ ಈಗ ಇದು ಮಾಡೋದು ಪೇಮೆಂಟ್ ಇರೋದು?
2,85 lakhs.
ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀರಿ ಈಗ?
ನಾನು ಒಂದು 25 lakhs ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ within 10 days.
30% of the amount is the rule.
I'll do that. Within
So,
3
subject
weeks,
to-
I'll do that.
Subject to petitioner depositing with the bank 30% of the amount in demand as under 10 each 1 week. Failing which interim order stands automatically rescinded and petition also may be dismissed.
It may also be noted that they are already before the DRT as well. That is also pending.
Let us. If you get at least 30% of the, you have to thank the court.
Obliged.
All.
Date maybe.
2 to 7 narrow rule. 2 to 7 narrow rule.
7.
Ah.
All other principal borrowers.
Yeah, 2 to 7.
To them.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಲಿ.
ಹೋಗ್ಲಿ.
ಅಲ್ಲಿ ನೋಡಮ್ಮ. Notice to all the parties.
My lords, if a date
At
could be
first.
fixed.
Ah.
If a date could be.
Notice ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲಮ್ಮ. ಸರ್ವ್ ಆದ್ಮೇಲೆ ಕೊಡಬಾರ್ದು. And it's not a good tradition that judge treating the matter at admission stage, fixing a date so that it will come before him only. That's a very bad practice. ಮಾಡಬಾರ್ದು ನಾವು. Yes. Wherever it goes first. Yes. ಶಿವಖಂಡೆ ಏನಿದೆ? ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ ಅವರು? This court wide order dated 6/12/2024 had said as under. Full stop. Next paragraph. Despite the above order, comma, review petitioner is neither review petitioner nor his counselor nor his counsel is present. Full stop. There is no representation either. Full stop. In view of that, call this matter for dismissal for non-prosecution on the next date of hearing. ನಾನು ಮತ್ತೆ ಸುಮ್ಮನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಬೇಡ, ಮತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರದು.
My presence, at least,
Huh?
my presence may be noted.
The presence and submission of counsel appearing for respondents, ನೋಡ್ರಿ, respondent and learned AG is noted or noted. Okay.
Respondent number 1.
One and science.
Published.
Yes. Nagaraja ಏನಿದು?
On the last date of hearing, after hearing, this honorable court has directed the government
ಫಾರ್ಮ್ 7 ಎದ್ದೇನು ಇದು?
filed by father.
ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್? ಫಾರ್ಮ್ 7 ವಾಸ್ ನೆವರ್ ಫೈಲ್ಡ್.
Endorsement to that.
ಫಾರ್ಮ್ 7 ಫೈಲ್ ಮಾಡ್ಲಿದ್ರೆ 7A ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ನಾವು ಅವ್ರಿಗೆ ಡಿನೈ ಮಾಡಿದ್ದು ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಬಿಕಾಸ್ ಸೆಕ್ಷನ್ 77A ಅನ್ನೋದು 77A ಅಲ್ಲಿ ವಾಟ್ ಐ ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ಇನ್ ನಾರಿಯಾ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದ್ಸರಿ ಓದಿಕೊಳ್ಳಿ. ನಾರಿಯಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಅಂಡ್ ಅದರ್ಸ್ ನಲ್ಲಿ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ಈಸ್ ವೇರ್ Form 7A application, Form 7 application under 48A is not filed, then Form 7 capital A is maintainable and hold madevu. Ali Form 7 is filed under 48 capital A, read with 44(1) of Land Reforms Act. That is for grant of occupancy. Aditya. Form 7A is not for grant of occupancy. It is for grant of land itself. ಈ ಡಿಫರೆನ್ಸ್ ಅನ್ನು ಮಾಡೇನು ಅವರು ನಾಗರಾಜ್ ಹೇಳೋದೇನು ಅಂದ್ರೆ ನಾ ಫಾರ್ಮ್ 7 ಹಾಕೇ ಇಲ್ಲ. ಹೌ ಕ್ಯಾನ್ ಯು ಡಿನೈ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಪ್ರೇಯರ್ ಫಾರ್ ಗ್ರಾಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೀಸ್ ಕೇಸ್ ಅಲ್ವಾ? ಮತ್ತಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದೆ. ರಿಕಾಲ್ ಮಾಡೋಣ, ರಿಕಾಲ್ ಮಾಡೋಣ. ಮುಂದೆ ವಿ ಕ್ಯಾನ್ ಹಿಯರ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಇಟ್ ಸೆಲ್ಫ್. ಮೇ ಬಿ ಬರ್ಕೊಳ್ಳಿ. ಬಟ್ ಟೈಪ್ ಫಾರ್ಮ್ 7A ಇದೆ ಅಲ್ಲ ನಾಗರಾಜ 41ದಲ್ಲಿ. 7A, ಓಕೆ, ನಾಟ್ ಫಾರ್ಮ್ 7. ಬರ್ಕೊಳ್ಳಿ. ದಿ ರಿವ್ಯೂ ಸೀಕ್ಸ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ dated 1/12/2022, whereby petitioner's WP number 19058 of 2019 was negatived on the premise that his application in Form 7 capital A, filed under Section 77 capital A of the Karnataka Land Reforms Act 1961 as amended, was not maintainable, since his application in Form 7 filed under Section 48 capital A of the Act was declined. First off, now learned counsel for the petitioner rightly draws our attention. Ellide the endorsement
59 annexure E 57 title copy is annexure 59.
59.
Serial number 4.
Endorsement. Date ಇದು ಏನಿದೆ ಏನು ಇಲ್ಲ ಇಲ್ಲಪ್ಪ.
Serial number 4. And annexure E. Page number 59.
ಇದ್ರ ನಮ್ಮ ಇದ್ರ ಡೇಟ್ ಹೇಳ್ಬೇಕು.
23/12/1998.
Dated endorsement dated 23/12/1998. A copy whereof avails at page 57. Correct? Which discloses that the review petitioner had not claimed occupancy by filing Form 7. First off. Next paragraph. In view of the above, the judgment dated 1/12/2022, in view of the above, review is allowed, review petition is allowed, and the judgment dated 1/12/2022 is recalled. First off, as a consequence, the writ petition is restored to the board for first off, registry to post it before the roster bench. All right. ಏನು ಕೈ ಮುಗಿಯಾಗೈತಿ, ನಮ್ ಡ್ಯೂಟಿ ನಾವು ಮಾಡಿರ್ತೇವಪ್ಪ. ನಾವೇನ್ ಕೈ ಮುಗಿಸೋಳು ಅಷ್ಟು ದೊಡ್ಡವ್ರೇನು ಅಲ್ಲ.
ನ್ಯಾಯಪೀಠ ಕೈ ಮುಗಿದು.
Anyway. ಏನಪ್ಪ ಇದು?
In this case, my lord, the petitioner is a police inspector. The allegation against him is that, my lord, there was a delay in registering of a FIR. The respondent number 4 has an inter-say with another person regarding a particular site in Nanjapa Garden, my lords. There are 3 suits pending with between both the parties pertaining to that particular site. Now, there is a dispute that occurs on 27/11/21, my lords, and a complaint is given by R4. The said complaint is given on 29/11/21, which is at page 26. I register the FIR
that is provided by her as crime number 226 of 21 on 29/11/21 itself. And the opposing party also gives a complaint, and I register their FIR as well as crime number 227 of 21.
1 second. Incident yavatappa?
Incident agodu 27/11/21 Swami.
11/20/21.
I register the FIR.
ಏನದು ಇನ್ಸಿಡೆಂಟ್?
Incident andre galate agate Swami, that they allege that there was an altercation between both the parties and the physical scuffle that happens. So she gives a complaint for offences under 427, 506, 341 of IPC.
ಯಾವತ್ತು ಕೊಟ್ರು?
The complaint is dated 29/11/21, my lords.
29/11 ಎಷ್ಟು ಗಂಟೆ ಕೊಟ್ರು?
My lords, the FIR is at page 28, my lords.
I am asking a question.
I'm sorry, my lords. My lords, the complaint is given at 9:15 in the night, my lords. 9:15 in the night.
AM.
PM.
PM.
21:15 ಅಂತ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
All right. ಇದನ್ನ ನೀವು ಅವ್ರು ಇದನ್ನ ಯಾವಾಗ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಿ?
My
Same
lords,
day.
Same day. 29/11 is the complaint. I register it on the same
Number?
crime number 226 of 21.
21. ಅವರು ಕಂಪ್ಲೇಂಟ್ ಯಾವತ್ತು ಕೊಟ್ರು?
The opposing party also gives the complaint on the same.
ಈ FIR ಕೊಟ್ಟವ್ರು ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್?
Respondent number 4.
Lakshmi.
Jayalakshmi. The opposing party, my lords, also gives a complaint.
ಅವ್ರು ಯಾರು?
Shankar Reddy anta, my lords.
ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟಿ ಅವರು?
Prakash and Shankar Reddy. They are not party to the proceedings, my lords.
ಪ್ರಕಾಶ್
Is the complainant, son of Shankar Reddy.
ಪ್ರಕಾಶ್ ರೆಡ್ಡಿ. ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ FIR ಯಾವಾಗ ಹಾಕಿದ್ರು?
Our complaint kuda, they give it on the same day, 29/11, but at 9:45 PM. And their complaint is registered as crime number 227 of 21.
9:45 PM.
9:45 PM. So it's a complaint on counter complaint.
Crime number 227.
227 of 21, my lords. So I've registered the complaint of R4 as the first complaint itself, my lords. My lords, after the registration of this FIR on 13/12/21, my lords, she goes and gives a complaint to SHRC. That complaint is at page 37, my lords. Her specific allegation is that she tried to give a complaint on 27th of November 21, and I caused a delay in registration of the FIR. As such, her human rights are violated, and she gives a complaint.
But our complaint ಕೊಟ್ಟಿದ್ದೆ 29ಗೆ.
29th. I've produced the complaint copy also, my lords. The complaint copy is available at page 26. The complaint copy nalle kuda date is affixed as 20.
ಏನಾಯ್ತು? ಕ್ರೈಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನೇನಾಯ್ತು?
My lords, the investigation was proceeding. In the meantime, the parties settled the dispute between them by executing a confirmation deed.
ಹೌದೇನ್ರಿ?
In fact, I've produced the registered confirmation deed as well, my lords.
ಎಲ್ಲಿದೆ?
Page 101 is the confirmation deed. My lords, in this, the first party is Jayalakshmi and her children. Page 101, my lords.
101 confirmation deed ಇದೆಯಲ್ಲ?
And it is in favor of the accused, which is Prakash Reddy. My lords, the most interesting aspect, my lords, page 109 for a moment. Page 109 for a moment, my lords. The list of civil disputes are recorded, and at page 111, paragraph 11 for a moment, if I may read, my lords. Page 111, paragraph 11, my lords.
ಅದು OSA, MFA, RFA ಇದಾವೆ.
ಎಲ್ಲ ಆದ್ಮೇಲೆ at page 111, my lords.
111.
Paragraph 11, if I may kindly.
Crime number 226 also.
Of the the most important is the language, my lords. That's being the case on hand. The parties of the first party have approached the party of the second party, agreeing to compromise all pending litigation against her, which are pending adjudication before various courts, including crime number 226 on the file of Hennur Police Station and crime number 156 of 22 on the Hennur Police Station.
ಇದು ಯಾವ್ದಿದು? 156 of.
It is an earlier complaint, not during my purview, my lords.
Earlier ಅಲ್ಲ, subsequent.
Subsequent, so I'm sorry. Which have arisen due to pendency of the civil suit, wherein such criminal proceedings have nothing short to have being given color of that of a civil suit. And she receives 25 lakhs under this deed, which is recorded at page 113.
By check?
By check, my lords.
Check.
Check bearing number 070-485 Axis Bank, Kalyan Nagar.
There.
Page 113, my lords. 113. For this settlement, she receives 25 lakhs.
113.
113, my lords. Para 17.
Demand draft.
Demand draft, my lord.
This is dated.
My lords, this is dated 29/8/22.
And NHRC, SHRC complaint ಹಾಕಿದ್ದೆ ಯಾವಾಗ?
SHRC complaint ಹಾಕಿದ್ದು ಸ್ವಾಮಿ 13/12/21.
ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಇದು ಮಾಡ್ಕೊಂತಾರೆ.
ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಇದಾಗಿರುತ್ತೆ.
What can be now can't say, otherwise I would have levied heavy cost on her.
My lords, my respectful submission would be
that otherwise I wanted to impose heavy cost on you, on that lady. But all this has happened subsequent. We'll close this, brother. Close, man.
Please, my lord, humble submissions, my lord. I'm appearing for the KSHRC, my lord. Commission, my lord. My humble submission, this court has passed on reported judgment in this case, my lord. Only we are in recommendatory in the nature, my lord. Only recommendatory in nature.
Even otherwise recommendation will go now. Because they have compromised the issue. Even then you should fight the case. ಅದಕ್ಕೆ ನಾವನ್ನ ಹೋಲ್ಡ್ ಮಾಡಿದ ಅದನ್ನ ನಮ್ದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಇರಬೇಕು.
Yes,
ಕರೆಕ್ಟ್, ಯು ಆರ್ ರೈಟ್.
You are myself present.
ಸುಳ್ಳ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ಗೆಲ್ಲ ಹಂಗ್ ಮಾಡ್ಬಾರ್ದು. ಅಲ್ಲ, ನಿಮ್ ತಪ್ಪಲ್ಲ ಅದು, ಅವರು ಇವ್ರದ್ದು ಪಾರ್ಟೀಸ್ ಹಿಂಗ್ ಮಾಡಿರ್ತಾರೆ. ಅವ್ರಿಗೆ ಯಾರು ಅಪೀರ್ ಆಗಿಲ್ಲನು? ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಕೂತ್ಕೊಳ್ಳಿ. ಪೊಲೀಸರ ಮೇಲೆ ಸುಳ್ಳು ಕೇಸ್ ಹಾಕೋದೆಲ್ಲ ಈಗ ಎಲ್ಲ ಅದೊಂದು ಫ್ಯಾಷನ್ ಆಗಿಬಿಟ್ಟಿದೆ. ಎಷ್ಟು ಕೇಸ್ನಲ್ಲಿ ನಾವು ನೋಡ್ತಾ ಇದ್ದೀವಿ. ಐ ಆಮ್ ಸ್ಪೀಕಿಂಗ್ ಫ್ರಮ್ ಸ್ಟಾಟಿಸ್ಟಿಕಲ್ ಡಾಟಾ. ವೆರಿ ಗುಡ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ಇದ್ದಾರೆ ನಮ್ಮ ಸ್ಟೇಟ್ ನಲ್ಲಿ. ಎಷ್ಟು ಕೆಲಸ ಮಾಡ್ತಾರೆ, ಏನು ಅವ್ರಿಗೆ ಕೆಲಸ ಮಾಡಿದ್ದೆಲ್ಲ ನೀವು ಕರೋನಾ ಟೈಮ್ ನಲ್ಲಿ ಇದರಲ್ಲಿ ಜಸ್ಟ್ ಇಮ್ಯಾಜಿನ್ ಪೊಲೀಸ್ ಇಲ್ಲದ್ರೆ ಏನಾಗ್ಬೋದು ಅಂತ. ಹೌದಾ? ಎಷ್ಟು ಒಳ್ಳೆ ಒಂದು ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಇದೆ ನಮ್ಮ ಇದರಲ್ಲಿ. ಕೆಲವೊಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ದಲ್ಲಿ ಕೆಲವು ಲೇಟ್ ಆಗ್ತದೆ ಮಾಡ್ತದೆ, ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ಮೋಸ್ಟ್ ಆಫ್ ದ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ಅಂಡ್ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ಸ್, ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ಸು, ಇನ್ಸ್ಪೆಕ್ಟರ್ಸು, ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ಸು, ಅಸಿಸ್ಟೆಂಟ್ ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ಸು, ಅವರೆಲ್ಲ ಬಹಳ ಶ್ರದ್ಧೆಯಿಂದ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಸಿಸ್ಟಮ್ ಹಂಗಿದೆ. ಏನೇ ಎಲ್ಲಾ ಕಡೆ ಬ್ಲ್ಯಾಕ್ ಶೀಪ್ ಇರೋಂಗೆ ಎಲ್ಲಾ ಕಡೆನೂ ಇರ್ತಾರೆ, ದಟ್ ಇಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ಎಸ್ಪೆಷಲಿ ಅವರ ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಪೀಪಲ್, ದೇ ಆರ್ ಡೂಯಿಂಗ್ ವೆರಿ ವೆಲ್, ಗುಡ್ ಜಾಬ್. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ. ಅವರಿಗೆಲ್ಲ ತೊಂದರೆ ಕೊಡಬಾರ್ದು.
Commission is only recommendatory in nature. Commission only
Of
recommendatory.
course, recommended. You are right. You are 100% correct. Barkal. Kutul. Petitioner, a police officer, is knocking at the doors of writ court with the following principal prayers. 1-4. Next paragraph. Learned counsel appearing for the petitioner submits that the incident in question happened on 27/11/2021 and the FIR came to be lodged by the fourth respondent on 29/11/2021 at 9:15 PM, and that accordingly crime number 226 of 2021 is registered by the petitioner. First, same day, one Mr. Prakash Reddy, Prakash son of Shankar Reddy, also filed a counter FIR on the same FIR at around 9:45 PM, and therefore crime number 227/2021 is also registered. First off, he submits that in view of Apex Court decision in Lalita Kumari versus State of UP 2013 or 14 or 2013 SCC 1 SCC 1, comma. It is open to the station house officer
2014 volume 2 SCC 1.
2014 1 SCC
Volume 2 SCC 1.
volume 2 SCC 1 open to the police, the station house officer to hold a preliminary inquiry to ascertain prima facie truthfulness of the allegations, and in that some time might have been spent. Full stop. Therefore, the complaint of fourth respondent before the SHRC could not have been entertained at all. Full stop. He also draws attention of the court to the compounding or compromise recorded by and between the parties in page number
101.
Huh?
101.
In
Annexure G 101.
one ನಿಮಿಷ. Deed of confirmation dated 29/8/2022, whereby the fourth respondent complainant has received a sum of rupees 25 lakh by the demand draft and closed the disputes or litigations, including the subject oneness involved herein. First, so content arguing, he seeks grant of the relief as prayed for. First, next paragraph. Learned senior panel counsel appearing for the respondent State Human Rights Commission, and learned AGA Mr. Aditya appearing for the second and third respondents oppose the petition, contending that the report of the Human Rights Commission is only recommendatory and it is not enforceable proprio vigor, semicolon. It is always open to the petitioner police officer to submit his explanation to the competent authority who would consider the report to the state government who would consider the same on the basis of the report. First stop. That being the position. First stop. Learned panel counsel places reliance on a coordinate bench decision dated ಇದನ್ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲನು
ಆಗಿದೆ 5th February 2000
ರಿಪೋರ್ಟೆಡ್ ಏನದು ಏನಂತ ರಿಪೋರ್ಟ್ ಆಗಿದೆ
5th March 2024
in C. Girish Nayak and others versus state and others ನೋಡ್ಕೋಬೇಕು report in support of the said submission. First, next one. So contending they seek dismissal of the right petition. Having heard the learned counsel for the parties and having perused the petition papers, I am inclined to grant indulgence in the matter in as much as there is absolutely no delay in registering either crime number 226 of 2021 on the basis of FIR lodged by respondent number 4, Gentle Lady, or in registering crime number 227 of 2021 on the basis of the FIR lodged by one Mr. Prakash, son of Shankar Reddy. First off, the FIR discloses when the FIRs disclose the time of lodging and other particulars. Although the incident is said to have happened on 27/11/2021. First off. Next paragraph. The other reason for granting relief to the petitioner is that the lists and disputes between the fourth respondent and Mr. Prakash Shankar Reddy have been amicably settled by virtue of confirmation deed, registered confirmation deed dated 29/8/2022, a copy whereof is produced at Annexure G to the petition. At paragraph 17 of the said deed, the compromise in consideration of rupees 25 lakh received by the fourth respondent herein is recorded. First off, the same reads as under, the same reads as under. Next paragraph. There is a force in the submission of learned panel counsel appearing for the commission and the learned AGA appearing for the official respondents.
One and three.
Muruku ನೀವು ಬರ್ತೀರಾ?
Please, please.
ಅದಂಗೆ?
That is they made a part of the CH-07 only. That CH-07 also having the government police officials. That's why.
ವಿಜಯ್,
Yes,
ಮುರುಕು ನೀವು ಬರ್ತೀರಾ?
please.
Very difficult. Anyway, all right, we'll do that.
Please.
ಆ ರೀತಿ ಮಾಡಿ ಅದನ್ನ ಅವ್ರು ತೆಗೆದ್ಬಿಡು. ಲರ್ನೆಡ್ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಅನ್ಕೋತ AGA ಬೇಡ ಬೇಡ. That the report of the KHRC is only recommendatory.
Recommended nature.
Recommendatory. First off. However, it is likely to generate some affliction to the petitioner herein, which may affect his service career.
In fact, departmental inquiry is already initiated, my lords.
First off.
And my lords have stated earlier.
I am also told, it is told at the bar that a disciplinary inquiry on the basis of this report is also on. First stop. In view of the above, next full stop. This is not a happy thing to happen. Happy thing to happen. First stop. Next paragraph. In the above circumstances, RWP ಯಾವ್ದದು?
My lords, I have not challenged that because my lords had stated by order dated 21.
RWP ಯಾವ್ದು?
WP was separately was.
ಇದ್ರಲ್ಲೇ.
ಇದ್ರಲ್ಲೇ one. ಇದ್ರಲ್ಲೇನೆ.
Perfect. Next one.
It stayed.
In view of the above.
It stayed till
Huh?
it stayed till date.
Stay there.
It's
ಮುಗಿಸ್ಬೋಣ ಈಗೆಲ್ಲ. In view of the above, this petition is allowed. Semicolon. A writ of certiorari issues quashing the impugned report of KHRC. KSHRC. Dated
4/5/22, my lords.
4/5/2022. First off. As a consequence, the pending disciplinary inquiry against the petitioner is closed in his favor. In his favor. Yes.
Lordships are quashing the disciplinary inquiry, he may have to make the state a party.
Huh?
He may
Then
have to-
state is
He may
a,
have to make the authority a party, his superintendent.
at the hands of ಯಾರದು?
My lords, it is within the police hierarchy under the Karnataka State Police Act, my lord.
Rules.
Rules.
That goes, even that will go. But
Automatically.
is closed.
My lords,
Close.
also recommend H as well because of.
By closing, by quashing,
Automatically.
the, another,
Annexure F, which is order dated 24/8/22.
one second. By quashing, the order dated
24/8/22
24/8/2022 issued by
issued by respondent number 1, my lord.
first respondent and
Case charge order only, my lord.
ಅದೇ ಅದು ಕ್ವಾಶಿಂಗ್ ಮಾಡೇವಲ್ಲ ಅದೇ ಅದು
First
ಅಲ್ಲಿ
automatically
ಮ್ಯಾಲಿಂದ ಅದೇ
every-
ಕ್ವಾಶ್ ಇದೇನ್ ಬೇಡ ತೆಗೀದ್ and another is
Another is order dated 13/2/23 passed by respondent number 1 at annexure H.
order of the by quashing all the orders passed by orders and reports passed by the first respondent. Okay,
Aligree.
all. You should thank your friend who is so fair.
Deeply obliged, my lord. Deeply obliged.
ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಸುಮ್ನೆ ಅಪೋಸ್ ಮಾಡ್ಕೋತ ಕೂತ್ಕೊಂಡ್
Deeply obliged.
ಅಲ್ಲಿ the assistance rendered by panel counsel for the KSHRC is appreciated. Thank you.
My name, my lord, Gopal Krishna.
Shri, alle, panel counsel Shri, so and so
Gopal Krishna.
is appreciated.
I love it.
Okay. Tenure, Ramesh Kumar. Harshvardhan, ಏನ್ ಕೊಡಿ ಇದೆಯಾ entry mod, none appears for the parties. Entry order to continue till next date of hearing. ಯಾರು ಎಷ್ಟು ಯಾರು ಬರಲಿಲ್ಲ ಎಷ್ಟು ತಗ DST ಮಾಡಿ ಅಲ್ಲೇ ಶ್ರೀ learned DSG Shri Shanti Bhushan is requested to accept notice for respondents. ಇಲ್ಲ ಯೂನಿಯನ್ RCA DST ROC entry order to continue from the date petitioner serves copy of the petition on the learned DSG and not otherwise. Okay. Your disposal, na? All right.
ಬರ್ತೇನೆ ನನ್ನ ಹೆಸರು ಹಾಕ್ಸಿರಿ ಗೋಪಾಲ್ 2:30
ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಪೂರ್ತಿಯಾಗಿ ಭರ್ತಿ ಮಾಡದೆ ಮತ್ತು ಸಹಿ ಮಾಡದೆ ಖಾತೆ ತೆಗೆಯಲು ಬರುವುದಿಲ್ಲ ಆದರೆ ಇದರಲ್ಲಿ ತೆರೆದಿದ್ದೇವೆ ಎಂದಿರುತ್ತಾರೆ. ನಿಶಾನೆ ಪಿ 8ರ ಪುಟ 4 ಮತ್ತು 5ರ ಎಡಭಾಗದ ಜಾಗ ಪೂರ್ತಿಯಾಗಿ ಕಾಣುತ್ತಿಲ್ಲ ಎಂದರೆ ಹೌದು. ಕಾರಣ ಹೋಲಿದಂತಹ ಫೈಲ್ ಅನ್ನು ಪೂರ್ತಿಯಾಗಿ ತೆಗೆಯದೆ ಜೆರಾಕ್ಸ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದರಿಂದ ಕಾಣುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಯಾವುದೇ ಚೆಕ್ ಕ್ರಾಸ್ ಮಾಡದೇ ಇದ್ದರೂ ಸಹ ನಾವು ಆ ಚೆಕ್ ಅನ್ನು ಪಡೆಯುತ್ತೇವೆ. ಸದರಿ ಈ ಪ್ರಕರಣದ ಪ್ರತಿಯಾವಧಿ 1ರವರೆಗೆ ನಮ್ಮ ಬ್ಯಾಂಕಿನಿಂದ ದಾಖಲೆ ಪ್ರಕಾರ ಚೆಕ್ ಪುಸ್ತಕವನ್ನು ಕೊಡಲಾಗಿರುತ್ತದೆ. ಎಷ್ಟು ಚೆಕ್ ಪುಸ್ತಕಗಳು ಕೊಡಲಾಗಿದೆ ಎಂದು ನಾನು ಪರಿಶೀಲಿಸಿಲ್ಲ. ಪ್ರತಿ ಚೆಕ್ ಪುಸ್ತಕ ಎಷ್ಟು ಲೀಫ್ ಹೊಂದಿರುತ್ತೇವೆ ನಾನು ಪರಿಶೀಲನೆ ಮಾಡಿಲ್ಲ. ಉಳಿತಾಯ ಖಾತೆಯ ಚೆಕ್ ಪುಸ್ತಕ ನೀಡಲಾಗಿದೆ. ಆ ರೀತಿ 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಚೆಕ್ ಪುಸ್ತಕ ಕೊಟ್ಟ ಬಗ್ಗೆ ದಾಖಲಿದೆ. ಸದರಿ 1ನೇ ಪ್ರತಿವಾದಿಯ ಉಳಿತಾಯ ಖಾತೆ ನಿಶಾನೆ P8 ಕೊಡುವ ಕಾಲಕ್ಕೆ ಅಂದರೆ ದಿನಾಂಕ 2/1/15 ಚಾಲ್ತಿಯಲ್ಲಿತ್ತು. ಆದರೆ ಆಗ ಆ ಉಳಿತಾಯ ಖಾತೆಯ ಸ್ಥಿತಿ ನೋಡದೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಿಶಾನೆ P7ರಲ್ಲಿ ತೋರಿಸಿದಂತಹ ಚೆಕ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಆ 2 ಚೆಕ್ಗಳು ಮಹಾದೇವ್ ಎಂಬುವರ ಹೆಸರಿಗೆ ಡ್ರಾ ಆಗಿರುತ್ತದೆ. ಆ ಚೆಕ್ಗಳ ಬಗ್ಗೆ ನಮ್ಮಲ್ಲಿ ದಾಖಲೆ ಇದೆ. ಆ 2 ಚೆಕ್ಗಳನ್ನು ನಾನು ಹಾಜರುಪಡಿಸಬಲ್ಲೆ, ಆದರೆ ಕಾಲಾವಕಾಶ ಬೇಕಾಗುತ್ತದೆ ಎಂದಿರುತ್ತಾರೆ.
ಕಮಲಮ್ಮ's ಎಜುಕೇಶನಲ್ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಏನು?
ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಸಿಗ್ನೇಚರ್ ಆಗ್ತಾರೆ, ಅಲ್ಲಿ ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ಜಸ್ಟ್
ಏನ್ ಕಲ್ತಾರೆ, ಏನು ಎಜುಕೇಶನ್ ಏನ್ ಕಲ್ತಾರೆ?
ಅಲ್ಲ, ಲರ್ನ್ ಟು ದಿ ಲರ್ನಿಂಗ್ ಆಫ್ ಸೈನಿಂಗ್ ಅಷ್ಟೇನೆ.
Where have you contended that she is illiterate? Where have you pleaded that Kamalamma is illiterate? She does not know, she does not have knowledge of the whereabout. ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಕನ್ನಡದಲ್ಲಿ ಸಹಿ ಹಾಕಿ H. ನರಸಿಂಹಯ್ಯನವರು ಕನ್ನಡದಲ್ಲೇ ಸಹಿ ಹಾಕ್ತಿದ್ರು. 18 DVG ಅವರು ಕನ್ನಡದಲ್ಲೇ ಸಹಿ ಹಾಕ್ತಿದ್ರು.
ನಾನು
pleaded. ಶಿವರಾಮ್ ಕಾರಂತರು ಕನ್ನಡದಲ್ಲೇ ಹಾಕ್ತಿದ್ರು. ನಿಟ್ಟೂರು ಶ್ರೀನಿವಾಸ ರಾಯರು ಸಹಿತ ಕನ್ನಡದಲ್ಲೇ ಹಾಕ್ತಿದ್ರು. ನಿಮ್ ಜಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ನೋಡಿರಿ ನೀವು. ಹಂಗಾಗಿ ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇಲ್ಲಿಟ್ರೇಟ್ ಅಂತ ಹೇಳಿಕ್ ಆಗಲ್ಲ. ನಾನು ಇಲ್ಲಿಟ್ರೇಟು, ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಒಳ್ಳಿ ನಾಲೆಡ್ಜ್, ಇದೆಲ್ಲ ಹೇಳ್ಬೇಕು. What is her evocation? What is her age?
The age of Kamalamma Millard deposition noted. As on the 60 Millard, as on the date of deposition.
60. Which place she is resident of?
Malu.
Malu. What is her husband doing?
Husband is no more.
No, what was he doing?
Agriculturist. It is a granted land, agriculturist.
Agriculturist.
It was granted in favor of her.
Where have you pleaded she is an illiterate person? She has never seen any bank. She has never seen any bank, any
bank account ಇದೆ. ತುಂಗಭದ್ರಾ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇವ್ರು ಮೊದಲಿಂದ ಅದನ್ನ ಹಾಕಿದ್ವಿ. Exhibit P 10 to 14, 12 are the bank accounts in the name of Kamalamma at her native place. ಅದಿದೆ, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಇದೆ.
Illiteracy ಬಗ್ಗೆ, absence of worldly knowledge ಬಗ್ಗೆ pleading ಎಲ್ಲಿದೆ?
Pleading ಇದ್ದಂಗಿಲ್ಲ. Pleading ಇಲ್ಲ ಸರ್.
ಈ ರೀತಿ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ರಾ?
ಇಲ್ಲ.
ಬ್ಯಾಂಕ್ನವರಿಗೆ ಈ ರೀತಿ ನನ್ನ ಹೆಸರಿಗೆ ಫೇಕ್ ಅಕೌಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಕೋರ್ಟಿಗೆ ಬಂದಾಗ್ಲೇನೆ I came to know about all this opening of the account and the alleged encashment and everything. ಅಲ್ಲಿ ತನಕ ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಅದಾದ್ಮೇಲೂ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಹಾಗೆ
Procedure is incomplete. Signature, not signature compulsory. KYC ಯಾವಾಗ ಬಂತು? The concept of KYC came into banking law when?
KYC
Sorry.
ಎಲ್ಲ ಬೇಕಾಗುತ್ತೆ.
Sorry.
ಯಾವಾಗ ಬಂತು ಆದಿತ್ಯ?
PVC ಕಾನ್ಸೆಪ್ಟ್ ಯಾವಾಗ ನನಗೂ ಗೊತ್ತಿಲ್ಲ.
In fact, Tenon on banking law, Banerjee on banking law, they have dedicated chapters on that.
They appears to have issued KYC guidelines in 2005.
2005. This is a 2008.
Oh.
8.
Also coincided with the promulgation of the Anti-Money Laundering Act, Prevention of Money Laundering.
Money laundering.
And membership of the Financial Action Task Force, Task Force. 2005 Master Circular guidelines from the RBI. From time to time, then they will keep
Upgradation. Thank you. Because it was already there. What this is. Pleadings are very substandard pleadings. Standard pleadings. Not by any complaint. What does he do?
Is it?
ನಿಮ್ಮ ಅಪೋನೆಂಟ್ ಗೋವಿಂದ ರಾಜು
working at manager in ITC company.
ITC company.
Yes.
What is his qualification?
MBA.
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 ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಎಂತಾದ್ರ ಐತಾ?
Nothing.
ಏನ್ ಹೆಸರು ಫುಲ್?
ಗೋವಿಂದರಾಜ್.
ಎ ಗೋವಿಂದರಾಜ್ ಸನ್ ಆಫ್
ಅಶ್ವಥ್ ನಾರಾಯಣ ರೆಡ್ಡಿ.
ನೋಡ್ರಿ, ಎ ಗೋವಿಂದರಾಜ್ ಸನ್ ಆಫ್ ಅಶ್ವಥ್ ನಾರಾಯಣ ರೆಡ್ಡಿ ಯಾವ್ದಾರ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನಾಗಿದಾನ ನೋಡ್ರಿ. ಜಸ್ಟ್ ಯಾವ್ದ್ರ ಈಗ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಇಲೆಕ್ಷನ್ ಯಾವ್ದಾರ ನಿಂತಿದ್ರನ?
ಅವರು ಈಸ್ ಫ್ರಮ್
ನಿಂತಿಲ್ಲ.
ಯಲಹಂಕ. ಇದು ಮಾನೂರು ಪ್ರಾಪರ್ಟಿ ಇರೋದು. ಈಸ್ ಫ್ರಮ್ ಯಲಹಂಕ.
ಫ್ರಮ್ ಯಲಹಂಕ.
ಬೆಂಗಳೂರು.
Who are the witnesses to that receipt? Exhibit D4.
ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿದೆ.
D4 ಗೆ
ಎಸ್
ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ? ಅಲ್ಲೇ 10 on banking law ತರಿಸಿ.
PW7. ಸರಿ ಸರ್.
ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿದಾನೆ. ಎಸ್. PW 516.
Bank witness.
ಶ್ರೀನಿವಾಸ.
ಇದನ್ನ ಎಕ್ಸಿಬಿಟ್ P4 ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರ ನೀವು?
I have not received any sale consideration.
Did you dispute this P4?
Yes, my lord.
Exhibit P4 is disputed by you.
Yes, my lord. Para 9 of my written statement.
D4. ಅಲ್ಲ P4.
P4.
Dispute ಮಾಡಿರ ಇದನ್ನ?
In para, we have denied para 9, my lord.
ಎಲ್ಲಿದೆ?
At page 26.
26.
ಅಲ್ಲ P4 ಅವರು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳೋದಿಲ್ಲ ಇಲ್ಲೂ. We have paid that amount ಅಂತ ಹೇಳ್ತಾರೆ plain ನಲ್ಲಿ. That has been denied in para 7. Para 9, last my is para 9 of their averments.
ಅಲ್ಲ ಈ P4 ಅವ್ರು ಮಾರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲ, ಒಬ್ರು ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅಡ್ಮಿಟ್ ಮಾಡಿಸ್ಯಾರ ಅವರು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ. ಡಿಡ್ ಯು ಕಾಲ್ ಅಟೆನ್ಷನ್ ಆಫ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಟು ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ಆಸ್ಟರ್, ನೋಡಮ್ಮ ಇವ್ರು ಹಿಂಗ್ ಹೇಳ್ತಾರೆ, ಇದ್ರ ಬಗ್ಗೆ ನಿಂದೇನು ಅಭಿಪ್ರಾಯ ಕೇಳಿದ್ರ?
ಅದು
ಬೇರೆ ಸ್ಟೇಟೆಡ್
P1 ಗೆನೆ ಇದ್ ಮಾಡಿದ್ದೀವಿ ಅದನ್ನ. P1 ಇದ್ ಮಾಡೋದವರು. One minute.
ಕಷ್ಟ ಮಾಡ್ತಾರೆ ಅಲ್ಲ.
Para 3, my lord, of the cross examination of PW5.
Page number?
PW5, page 3. ಇದ್ರಲ್ಲಿ ಬೇಡಿ, ಇದು ಒರಿಜಿನಲ್ ತಗೊಳ್ಬೇಕು.
ಅಲ್ಲ ನಿಮ್ಮ ಪೇಪರ್ ಬುಕ್ ನಲ್ಲಿ ಪೇಜ್ ಹೇಳಿ.
ಒಂದು ನಿಮಿಷ. ಮೇಲೆ page 71. ಕೆಳಗಡೆ page 71. ಗೋವಿಂದರಾಜ್ 5 ವರ್ಷಗಳಿಂದ ಗೊತ್ತು 14,000 ಮುಖಾಂತರ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂಬ ಸಂಗತಿಯನ್ನು ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿಲ್ಲ. ತದವಿ 12,20,000 ಹಣವನ್ನು ಕಮಲಮ್ಮನಿಗೆ ನಗದು ರೂಪದಲ್ಲಿ ಪಾವತಿ ಮಾಡಿದೆ ಎಂದು ನನ್ನ ಸಾಕ್ಷ್ಯ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಏನು ಹೇಳಿ ಬರೆಸಿಲ್ಲ. ದಿನಾಂಕ 27/2/2008 ಅಗ್ರಿಮೆಂಟ್ ಆದ ಬಗ್ಗೆ ಹಣ ಪಡೆದಿದ್ದಕ್ಕೆ ಹಿಂಬರಹ ಹಾಕಲಾಗಿದೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ. ನನ್ನ ಸಮಕ್ಷಮದಲ್ಲಿ ಯಾವುದೇ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡಿಲ್ಲ, ಆದರೂ ಸಹ ಸುಳ್ಳು ಸಾಕ್ಷ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಕಮಲಮ್ಮ ಆಗಲಿ ಹಾಗೂ ಉಳಿದವರು ಆಗಲಿ ಅಗ್ರಿಮೆಂಟ್ಗೆ ಸಹಿ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಹಣ ಪಡೆದ ಸಹಿ ಮಾಡಿದ್ದಾರೆ ಎಂದಿರುತ್ತಾರೆ. ದಿನಾಂಕ 27/2/2008 ಪ್ರತಿವಾದಿಯರು ಯಾವುದೇ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಹಣ ಪಡೆದು ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದಿದ್ದಾರೆ.
ಯಾರ್ದಿದು ಇದು ಎವಿಡೆನ್ಸ್?
ಹನುಮಾನ್ ವಿಟ್ನೆಸ್ ಟು ದಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಡಾಕ್ಯುಮೆಂಟ್ಗೆ ಅಲ್ಲ, ನಿಮ್ಮ ವಿಟ್ನೆಸ್ ಎಲ್ಲಿದೆ ಇದ್ರ ಮೇಲೆ? ಈಗ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ಸ್ ಆನ್ ಲಾ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಸೇ ಲೈಕ್ ಕ್ರಾಸ್ ಆನ್ ಎವಿಡೆನ್ಸ್, he says where a plaintiff admits a particular document to the record of the evidence.
Yes, ma'am.
If that is to be disputed,
yes, ma'am,
the attention of the party should be drawn,
yes, ma'am,
to that document and you should have his say on it. ಅದೆಲ್ಲಾಗಿದೆ ಇದರಲ್ಲಿ?
Correct. PW1, my lord, page 46.
ನೀವು ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು ಅವಳಿಗೆ ಕನ್ಫರ್ಮ್ ಮಾಡಿರಾ ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ? ನೋಡಮ್ಮ ಇವ್ರು ಹಿಂಗ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀಯ ನೀನು? ನಿಮ್ಮನ್ನ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ದೀವಿ.
ಕಮಲಮ್ಮ ವಾಸ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್.
Kamalama is not been examined.
ಅವ್ರ ಪರವಾಗಿ ಯಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ?
Vijay Kumar, madam.
ಯಾರವರು?
Son.
ಹೌ ಸನ್ ವಿಲ್
ಅಲ್ಲ, ಎಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಕೊಟ್ಟರೆ ಎಲ್ಲ ಅವರೆಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊ, ಇವ್ರೊಬ್ಬರೇ ಎಲ್ಲ ಮಾಡ್ಕೊಟ್ಟಿರೋದು. ಚಿಲ್ಡ್ರನ್ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಮೇಲೆ
ಅಲ್ರಿ ಈಗ ಎಕ್ಸಿಬಿಟ್ ಈ ಕಮಲಮ್ಮನ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡು ಬೆಳವಲಮ್ಮ ಹೇಳಿಕ್ ಬರಲ್ಲ, ಕಮಲಮ್ಮನೇ ಹೇಳ್ಬೇಕಾಗ್ತದೆ.
DW4 ಮೇಲೆ ಸಾರಿ, DW4 ಕಮಲಮ್ಮ 143
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರಾ?
143
ಪೇಜ್ ನಂಬರ್
143.
46.
Cross examination is at page 151.
ಬಟ್ ನಿಮ್ ಓರಲ್ ನಾವು ಫಸ್ಟ್ ನಿಮ್ ಚೀಫ್ ನೋಡೋಣ ಯಾವ ರೀತಿ ಹೇಳಿರಿ ಚೀಫ್ ನಲ್ಲ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಬಗ್ಗೆ ಏನಾರ ಹೇಳಿರಾ? Come to 146 para 4.
I do swear that after this notice stage, the plaintiff only with a malevolent intention to defraud the defendants has illegally and high-handedly to deprive the balance amount of rupees so and so that was agreed to be paid to the defendants has created the sale deed on so and so on the basis of the general power of attorney for himself, which was already cancelled, and the knowledge of the plaintiff only that and this alleged sale deed is created in contravention of the sale agreement agreed between the parties to the suit, and hence it is clearly violation of the terms and conditions embodied in the sale agreement. Hence the sale deed is liable to be cancelled under law. Therefore, absolutely the plaintiff will not derive any right, title, interest, or even possession. The possession of the suit property is still with the defendants only, and it is not delivered in the title.
ಅಲ್ಲ ಅದು ಎಕ್ಸಿಬಿಟ್ P4 ಮೇಲೆ ಇರುವಂತ ಕಮಲಮ್ಮ ಅನ್ನುವಂತ ಸಹಿ ನನ್ನದಲ್ಲ, ಅದು ಸೃಷ್ಟಿಸಿದ್ದು.
That is not stated.
ಎಲ್ಲಿ ವೇರ್ ಹ್ಯಾವ್ ಯು ಸ್ಟೇಟೆಡ್?
It is not forthcoming. Page.
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕೊಡ್ಬೇಕು ಅಂತಿತ್ತು ಅಗ್ರಿಮೆಂಟ್ ನೋಡ್ರಿ ಗೊತ್ತಾಗ.
Page 152 my lad. 152.
Within 2 days. Within what period remaining amount was to be paid under the agreement? Yes, period.
After completion of that
Non-eligible period.
there was a bar.
Why did you give that money without that?
They have requested for urgency.
Huh?
They have
Within 2 days?
Yes, yes,
Within 2 days only?
yes, yes.
Where have you stated that? Where have you explained that?
And
In
it-
your pleadings?
My pleading. Yes.
ಅವತ್ತೇ ಕೊಟ್ಬಿಡ್ತಿದ್ರಿ ಹಂಗಿದ್ರೆ.
ಹ್ಮ್.
2 ದಿವಸದಲ್ಲಿ ಕೊಟ್ಟಿರ ಉಳಿದಿದ್ದ ಅಮೌಂಟ್ ಎಲ್ಲ.
Page number 6, ಹೌದು 2 ದಿವಸ.
Page 6.
Yes. Para number 5. Paper book.
If it is a precondition.
May I read, madam?
Where is the agreement? Let us see the
Exhibit
terms of the
P1.
agreement. Huh?
Exhibit P1.
P1.
Yes.
Page number?
Your Lordship take original.
But ಹಂಗಲ್ಲ ಈಗ precondition comply ಆಗೋ ಹೊರತು in fact that is the stand they have taken in their reply also.
I request my Lordship to take original of Exhibit P1.
ಇದೇನು ಮಿಸ್ಟೇಕ್ ಇದೆಯೇನೋ?
Registration ಎಲ್ಲ ಬಂದಿಲ್ಲ ಹಿಂದ್ಗಡೆ.
ಅದು ಇರ್ಲಿ ಬಿಡಿ, ಅದಿರ್ಲಿ. ಈ ಟರ್ಮ್ಸ್
Then it's okay.
ಯಾವಾಗ ಮಾಡಿ ಕೊಡ್ಬೇಕು, ಉಳಿದಿದ್ದ ಅಮೌಂಟ್ ಯಾವಾಗ ಕೊಡ್ಬೇಕು, ರಿಜಿಸ್ಟ್ರೇಷನ್ ಯಾವಾಗ ಮಾಡ್ಬೇಕು ಅಂತ ಇದಕ್ಕೆ ತೋರಿಸಿ.
ಇದೆ. Page number 80. 83 mail. It starts from 83 exhibit.
ಅಲ್ಲ ಅದು 83 ಬಿಗಿನ್ ಆಯ್ತು. Where is that condition?
Condition is that,
At the time of at the time of
Obtaining permission from government for
Yes, ma'am.
eliminating the scheduled property, paragraph 9.
please, ma'am.
Is it not?
The vendors agrees to execute
Execute
the
the
sale
sale
deed
deed.
either in the terms, in the name of the purchaser or is in the nominee immediately after obtaining permission from government for alienation of the scheduled property. This is the
If that
condition.
is so,
Yes, ma'am.
and that is your stand,
Yes.
even in your reply
Yes.
to the legal notice.
Yes.
How is that you made entire payment when this was not yet applied for?
Because of
And
that.
you are not some Kallegowda, Mallegowda. You are working, you are MBA.
Yes.
Mate?
Because they have demanded immediate.
But where did
urgency.
you alter? All right, where you did not alter this condition?
We are under the hope that they have executed general power of attorney coupled with interest, my lord. Kindly see, it is irrevocable.
Coupled with interest, it will be hit by section 4 of the act which requires the permission. Coupled with interest, full stamp duty ಕೊಡ್ಬೇಕು ಅದಕ್ಕೆ.
We have paid.
Full stamp duty is paid on the GPA.
Yes, my lord.
Whatever is payable under Article 5.
5, yes, my lord.
You have paid interest.
Therefore, we have executed the sale deed in my name only. For that reason only, I have paid the full stamp duty. Otherwise, they does not permit. Their contention is that I have executed sale deed in my favor only because I have paid full stamp duty.
Second rate pleadings. Great interest. Correct. Now you collect the money and you put it in your own pocket, then it will be creation of interest, otherwise. Merely because stamp duty is paid, that makes no sense at all. So when you can say there is one judgment of Justice Shivashankar Bhatt, Honorable Justice Shivashankar Bhatt and Vasant Kumar. It says when interest is created, when a GPA creates interest in the agent, only entire amount ನೀವು ಕೊಟ್ಟಿರಬೇಕು, ಅವಾಗ ಪ್ಲಸ್ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಏನು ಕೊಟ್ಟಿರಬೇಕು ಕಂಪ್ಲೀಟ್ಲಿ, ಆ ಟೈಮ್ ನಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಆಗಿದೆ ಅನ್ಕೊಂಡು ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಬರ್ತದೆ. GPA is registered.
Yes,
registered.
it is registered.
Then it can be created as coupled with interest.
Section 205 of Contract Act.
Correct. Otherwise,
they have not complied before cancellation of the GPA. They must offer me that compensation. Without offering me compensation, they cannot cancel it. That is the law.
But how is that, pleadings ಎಲ್ಲ ಬಹಳ bad pleading. Perhaps the person who has drafted these pleadings has never read any standard book on law of pleadings like PC Moga, Ojers, Shugopal, and plaints by Majumdar. ಎಲ್ಲ ಏನು ಓದಲ್ಲ, ಹಂಗೆ ರಂಟಿ ಹೊಡ್ಕೊಂಡು ಹೊಲದಿಂದ ನೇರವಾಗಿ ಬಂದ್ಕೊಂಡು ಬರ್ದಂಗಿದೆ ಇದು. ಹಿಂಗಾಗ್ತದೆ ಸಮಸ್ಯೆ. Where have you stated Exhibit P4 is a forged document? The signature of Kamalamma appearing on that, purporting to appear in my name, is not my signature.
52, page 152.
152.
It was confirmed, page 152. In the middle milan. It was confronted to the witness. ನಿಶಾನೆ P4 ಮೇಲೆ ಇರುವಂತ ಸಹಿ ನನ್ನದಲ್ಲ.
ಎಲ್ಲಿದೆ ಅದು?
1, 2, 3, 4, 5, 6, 7, 8, 9. 9th line from the bottom. ನಿಶಾನೆ P4 ಮೇಲೆ ಇರುವಂತಹ ಸಹಿ ನನ್ನದಲ್ಲ.
You have said that.
Yes, madam.
Exhibit P4. ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ತೊಳಿಲ್ಲ.
ಡಿನೈ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇನೆ.
ಏನಂತ?
ವಾಟ್ ಎವರ್ ದ ಅಮೌಂಟ್ ಪೇಡ್ ಇಸ್
ಅಮೌಂಟ್ ಪೇಡ್ ಇಸ್ ನಾಟ್ ಪೇಡ್ ಅಂತ.
ಈವನ್ ಇನ್ ಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P4 ನಲ್ಲಿ ಏನು ಹೇಳೋದಿಲ್ಲ. There is no averments in plaint regarding exhibit P4.
No, he could not have said because in P4 ಬಗ್ಗೆ ಇವ್ರು ರೆಫರ್ ಮಾಡ್ದಂಗಿಲ್ಲ.
Is there.
Plaint
In my
ನಲ್ಲಿ
pleading- my pleading, kindly see para 9 of the plaint.
you refer to
Yes,
exhibit
yes.
P4.
ಯಾಕೆ ನಾನು ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ನಾನು ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲೇ ನಾನು ಅಲ್ಲಿ ಬಿಲ್ಡ್ ಅಪ್ ಮಾಡಿದ್ದೀನಿ. The plaintiff under fond hope trusted the defendant and paid the entire balance sales consideration amount vide demand draft drawn in the name of the first defendant bearing number so and so drawn on Axis Bank for a sum of rupees 14,37,500 and further sum of rupees 12,25,000 was paid by cash. I have pleaded it.
P4 ಗೆಲ್ಲಿದೆ ರೆಫರೆನ್ಸ್.
ಅದೇ paid by cash 12,25,000.
ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡಿವಿ ಅಂತ ಎಲ್ಲಿದೆ?
My lord.
In that connection, a document is receipt is drawn ಅಂತ ಎಲ್ಲಿದೆ? How he can deny in the plaint?
I have produced it in the evidence. Yes, ma'am. The plaintiff has paid the entire sale consideration amount as per the agreement of the sale. The first defendant executed an agreement dated 27/2/2008 acknowledging the receipt of the payment and also authorized the plaintiff to execute the powers of registration of the properly on the basis of the general power of attorney as they had received the entire sale consideration amount.
They should have sent it for forensic examination. We can have the additional piece of evidence. ಅದನ್ನ ಎರಡು ಕಡೆ ಸಿಗ್ನೇಚರ್ ಹೋದಾಗ Which bank it was? Bank open?
Axis Bank.
ಅಲ್ಲಿ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ DD ಆಂಧ್ರ ಬ್ಯಾಂಕ್
ಅಕೌಂಟ್ ಓಪನ್
ಆಗಿದೆ. ಬೆಂಗಳೂರು.
Andhra Bank is also nationalized.
Yes, yes, national.
ಬೆಂಗಳೂರು.
Marathalli. The manager of both the bank have been examined. Both the bank. TD issue ಮಾಡಿರೋ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಯಾವ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಡ್ರಾ ಆಗಿದೆ ಆ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಅವರು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಂಧ್ರ ಬ್ಯಾಂಕ್ ಇದೊಂದೇ ಟ್ರಾನ್ಸಾಕ್ಷನ್, ಬೇರೆ ಯಾವ್ದಿಲ್ಲ. ಇಲ್ಲ, ಬೇರೆ ಯಾವ್ದಿಲ್ಲ.
ನಿಮ್ಮ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಎಷ್ಟು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ?
ಅದು ಎಕ್ಸಿಬಿಟ್.
They have not taken any action after this incident. Kindly see in the pleading itself I have stated that 14 lakhs DD ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳಿದೆ. ಅದಾದ ನಂತರ 2012 ಸೂಟ್ ಇದು, 2016 ಅಲ್ಲಿ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದು. In the meantime they have not taken any action on that finding all.
Agreement is on, this bank account is opened on the date of the agreement.
ಹೌದು, yes,
Same day.
ಸೇಮ್ ಡೇ ನಾವು ಅದು ಅಮೌಂಟ್ ಕೊಟ್ಟಿರೋದು.
29th.
Within 2 days entire amount has been paid.
All right. ಆ 5 lakhs ಅಲ್ಲೇ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತಿತ್ತಲ್ಲ ಈ ಅಕೌಂಟಿಗೆ. The 5 lakhs which you had given in, you could have credited it to this account only.
No, at a time, we cannot pay entire amount. This is next day they have demanded and we have paid the remaining amount, entire sales consideration.
In fact, the bank account is opened on the date of the agreement itself demonstrates that the need for the money was not 2 days later.
However, my lord, as per the Bankers Book of Evidence Act, it is presumed that they have not disputed this transaction. It is proved by the bank authorities itself. It has been drawn by the prospective account holder.
Im appeal is there challenging.
Yes, my lord. I filed cross objection. Since the Honorable Trial Court ordered for return of that DD amount and sale agreement amount, 5 lakhs, that is total 19 lakhs something with 12% interest. And the land remains with them. That is the order passed by the Learned Trial Court by exercising power under Order 7 Rule 7 of CPC. Therefore, I have also filed appeal.
ಅದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಆಗಿದೆ ಡಾಕ್ಯುಮೆಂಟ್?
ಅದು ಫಸ್ಟೇ 5:30ಗೆ GPA ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ, 5:30 ಟೈಮ್ ಆಗೋಗಿದೆ ಅಂತ ಅದನ್ನ ಪೆಂಡಿಂಗ್ ಇಟ್ಬಿಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇ 26th ಅಗ್ರಿಮೆಂಟ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ. ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದು ಪೆಂಡಿಂಗ್ ಇಟ್ಟು
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ವಾಸ್ ಓಪನ್.
ಎಸ್, ಅವತ್ತೇ ಆಗಿದೆ.
ಅವತ್ತೇ ಆಗಿದೆ. ಅಮೌಂಟ್ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಅಕೌಂಟಿಗೆ ಹಾಕಕ್ ಬರ್ತಿತ್ತಲ್ಲ, ಅಮೌಂಟ್ ಒಪ್ಕೊಂಡ್ರಿ ನೀವು?
ಅದು ತಗೊಂಡಿದ್ದಾರೆ, ಅಡ್ಮಿಟೆಡ್ ಅದು ಅಕೌಂಟ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು
ದಟ್ ಹ್ಯಾವ್ ಟು ಪೇ
5 lakh rupees ನಾವು ಚೆಕ್ ಕೊಟ್ಟು ಅದು ಎನ್ಕ್ಯಾಶ್ ಆಗಿದೆ. They are not denying that. The agreement GPA both are coupled with interest. They are not disproving.
ಕಪಲ್ಡ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಅನ್ನಂಗಿಲ್ಲ. ಅದು ಕಪಲ್ಡ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿಕ್ಕೆ ಇಂಡಿಶಿಯಾ ಬೇಕಾಗ್ತದೆ. ಅವಾಗ ಕಪಲ್ಡ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಗ್ತದೆ. 91 ILR 92 ನೋಡ್ರಿ, ಶಿವಶಂಕರ ಭಟ್ ಅಂಡ್ ಜಸ್ಟಿಸ್ ವಸಂತ್ ಕುಮಾರ್ ಜಜ್ಮೆಂಟ್ ಅದು ಅಂಡರ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಆಕ್ಟ್.
Section 205 is very clear, my lord.
ಬಟ್ ಅವತ್ತೇ ಹೆಂಗೆ ಓಪನ್ ಮಾಡ್ತಾರೆ ಇದು ಅನ್ನೋದು ಸೇಮ್ ಡೇ ಇಟ್ ವಾಸ್ ಓಪನ್. ನಿಮ್ಮ ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅಕೌಂಟ್ ನಲ್ಲಿ ಏನೇನ್ ವ್ಯವಹಾರ ಮಾಡಿರಿ ನೀವು?
Page ಸುಮಾರಿದೆ transaction. I have produced exhibit D12.
D12 ಪೇಜ್ ನಂಬರ್
11 and 12, my lord. Page 199. Page 199, my lord. ಆಮೇಲೆ 201 7ನೇ ಇಸ್ವಿಯಿಂದ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇದೆ. 201
Number 2, she have disclosed that bank account here. ಅಲ್ಲಿ ಕಾಲಮ್ ಇರ್ತದೆ, ಅಲ್ಲೊಂದು ಕಾಲಮ್ ಇರುತ್ತಲ್ಲ, ಬೇರೆ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಖಾತೆ ಇರುತ್ತದೆಯಾ ಅಲ್ಲಿ ಏನಂತ ಇದೆ ಅಲ್ಲಿ 10 ನಾನು ಬ್ಯಾಂಕಿಂಗ್ ಲಾ ತರಿಸ್ರಿ. ಅಲ್ಲೊಂದು ಕಾಲಮ್ ಇರ್ತದೆ, ಅಲ್ಲಿ ಏನಂತ ಇದೆ?
KYC starts from page number 115 of paper.
Correct. Pleadings, evidence, ಭಾರಿ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅದು. ಓದೋದಿಲ್ಲ ಅವರು, ಓದಂಗೆ ಹಂಗೆ ಯಾವುದೋ ರೈಸ್ ಮಿಲ್ ನಿಂದ ಅಥವಾ ಚೌಟ್ರಿಯಿಂದ ಬಂದು ಪ್ರಿಂಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡ್ತಾರೆ. ಪ್ಲೇಸ್ ಡ್ರಾಫ್ಟ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ಲ್ಯಾಂಡ್ ನಿಂದ ಹಗಲೆಲ್ಲ ಲ್ಯಾಂಡ್ ಟಿಲ್ಲಿಂಗ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ ಹೋಗ್ತಾರೆ. ಹೆಂಗ್ ಬರ್ತದೆ ಅದು? ವಿದ್ಯೆ ಅದು ಹಂಗೆ ಬರುತ್ತಾ? ಸಾರಸ್ವತ ಲೋಕ ಅದು.
Most of the columns are left blank, date ಇಲ್ಲ, ಎಂತದಿಲ್ಲ.
ಅಲ್ಲಿ ನೋಡಿ ಅಕೌಂಟ್ ಕಮ್ ಟು ಇದರಲ್ಲಿ ಎನಿ ಅದರ್ ಬ್ಯಾಂಕ್ ಅಂತ ಇರೋ ಕಾಲಮ್ ಅಬ್ಸೆಂಟ್ ಇದೆ.
ಎಲ್ಲ absent, ಎಲ್ಲ absent, date absent.
ಡೇಟ್ ಅಬ್ಸೆಂಟ್, ಇದು ಎಲ್ಲ ಅಬ್ಸೆಂಟ್ ಇದೆ. ಇಂಟ್ರೊಡ್ಯೂಸರ್ ಹೆಸರಿಲ್ಲ, ಬರೀ ಸಿಗ್ನೇಚರ್ ಗೀಚಾರ, ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ. ಮುಖ್ಯವಾಗಿ ವೈ ಶಿ ವಿಲ್ ಗೋ ಫಾರ್ ಅನದರ್, ಶಿ ಇಸ್ ನಾಟ್ ಎ ಬಿಸಿನೆಸ್ ವುಮನ್. Why she will go for that account at all? This runs contrary to our common sense.
The agreement agreement executed by not only this Kamalamma, his son Vijay Kumar, he has been examined as DW1. He was the, he was running a press. He is very knowledgeable person. Therefore, they cannot plead that.
Why was his signature taken on the receipt?
Receipt ನಲ್ಲಿ ಅವನ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲಲ್ಲ, ಸಾಕ್ಷಿಯಾಗಿರೋ ತಗೋಬಹುದಲ್ಲ.
No, even the DD also given in the name of Kamalamma. That 5 lakh rupees advance amount is also given in the name of Kamalamma only.
Admit ಮಾಡಿಬಿಟ್ಟಾರೆ.
Since she is the head of the family,
why she will go for another bank account? What is the reason? Common section 114 of Evidence Act ನೋಡಿ. Court may presume certain things based upon common course of events, knowledge, the human conduct. ಆ ರೀತಿ ಇದೆ. Now we have to answer that question. Why Kamalamma? She is not a business woman.
yes, my lord. Right, my lord. Right, my lord. They,
Why she will go for another bank account? That too on the same day of the agreement.
after knowing this fact, my lord, till today they have not taken any action.
No, she is ignorant. Ignorance operates in all activities, all pervasive. Account opening account proper. Aditya. How accounts are opened? There is one chapter on that. Just see that.
While opening this bank account, my lord, she has given the voter ID, my lord. That voter ID has been tendered in the evidence that she
Voter
admits.
ID
she admits
registration ಮಾಡಿದ್ರಲ್ಲ ನೀವು agreement, ಅವಾಗ ನಿಮ್ಮ ಮತಿಗೆ ಇದ್ದು ಬಿಡ್ತದೆ.
voter ID and photo, everything she accepts.
ಅವಾಗ ಅದ್ರಲ್ಲಿ ಇದೆ, registration ನಾಗೂ ಇದೆ.
ಅಲ್ಲ, ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ ಫೋಟೋ ಬೇಕಾಗಿರಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಈಗ ಎಲ್ಲ ಡಿಜಿಟಲೈಸ್ಡ್ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಫೋಟೋ ತಗೊಳ್ತಾ ಇರಲಿಲ್ಲ.
ಹಾ, ಬಟ್ ನಂಬರ್ ಗಿಂಬರ್ ಬೇಕಲ್ಲ, ನಂಬರ್ ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಫೋಟೋ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಫೋಟೋಗ್ರಾಫಿ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ.
ಬ್ಯಾಂಕ್ ಅಕೌಂಟಿಗೆ
ಅದು ಅವ್ರು ನಮ್ದೇ ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ.
ಫೋಟೋ ಅವ್ರದ್ದೇ ಇರ್ತದೆ, ಒಪ್ಕೋತಾರೆ. ನಂದು ಯಾವ್ದೋ ಫೋಟೋ ತಗೊಂಡು ನೀವು ಅಕೌಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಕ್ವಶನ್ ಈಸ್, why Kamalamma will go for second account? She is not a business lady. ಎರಡನೇ ಅಕೌಂಟ್ ಯಾಕೆ ಬೇಕಾತ ಅವಳಿಗೆ? That too on the day of the agreement itself. How she will go for that? Number one. Number two, KYC columns all are blank. Number three, she has not stated her bank account. ಅವಳು ಮಾಡಂಗಿದ್ರೆ, ಸ್ವಾಮಿ ನಂದು ಇಂಥ ಅಕೌಂಟ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಇದೆ, ಅದನ್ನೊಂದು ಬರ್ಕಳಿ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳ್ತಿದ್ರು. ಅವ್ರು ಕೇಳೇ ಬಿಡ್ತಿದ್ರು ಬ್ಯಾಂಕ್ನವರು, ಅದು ಖಾಲಿ ಇದೆ. Why Kamalamma will go for another bank account? ಏನು ಬಿಸಿನೆಸ್ ಮ್ಯಾನ್, ಬಿಸಿನೆಸ್ ವುಮನ್ ಅಲ್ಲ, ಎಂತದಲ್ಲ. Why she will go for that? That you have to account for.
His son looking after everything.
ಏನಂತ?
The transactions.
ಅವನ್ ಸನ್ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ P4 ಗೆ.
ಇಲ್ಲ, but he is the behind that transactions.
ಹಂಗಿದ್ರೆ
every transaction took place between the son of defendant number 1 and plaintiff. ಯಾಕೆಂದ್ರೆ ಖಾತಾ stands in the name of Kamalamma, therefore entire amount has been given in her name only.
endorse to the agreement.
Only one
Yes.
has signed.
One person signed the receipt, which is fine.
6 persons
You
in
put
the
it- you
agreement.
Give the consideration to one person, but your exhibit P4 is only one.
One, and when it was agreement for 5 lakhs, 6 persons have signed. ಇಲ್ಲಿ 14 lakh odd ಇದೆ, ಅವಳೊಬ್ಬರದೇ signature. How? First hurdle you have to overcome. Why she goes for another bank account? ನಿಮ್ ರಿಪ್ಲೈ ನೋಟಿಸ್ ನಲ್ಲಿ ಈ ಅಮೌಂಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, ರಿಪ್ಲೈ ನೋಟಿಸ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ,
ನೀವು ಇಂಥದ್ದು ಇಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡಿ ಇಂಥ ಎಕ್ಸಿಬಿಟ್
clarify-
ಟೈಪ್ ಇದೆಯಲ್ಲ,
clarify.
ಡಾಕ್ಯುಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿ, ಇದೆಲ್ಲ ಎಲ್ಲಿದೆ? Something fishy.
kindly see, they have cancelled the general power of attorney on 1/10/2010, my lord. And they have issued the legal notice thereafter, 8/12/2011. They have cancelled the general power of attorney on 1/10/2010. And they have issued the notice calling me to for registration on 8/12/2011. In that notice, nowhere they have stated that we have cancelled the GPA.
ಅದು ಬಿಡಿ, GPA ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವು ಬಂದು ನಿಮ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಯಾರ ಅವರು.
Already, ಇದು ಟೈಮ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿಲ್ಲ. ಟೈಮ್ ನಾಟ್
ಅಲ್ಲಿ ಅದ್ರ
therefore ನಾನು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಏನಂತ?
In the my reply notice, I have stated that.
ಆಯ್ತು, ರಿಪ್ಲೈದಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ ಗೊತ್ತಾ? ನೀವು ಅದು ಪರ್ಮಿಷನ್ ನೀವು ತಗೊಂಡಿಲ್ಲ ಅಂತ. ಹಂಗಿದ್ರೆ
ಪರ್ಮಿಷನ್ ತಗೊಳ್ಳಿ, ನಾವು ಬಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ನಾನು ಹೇಳಿದ್ದೀನಿ.
ಹಂಗ ದುಡ್ಡು ಯಾಕೆ ಬಿಟ್ರಪ್ಪ? ಪರ್ಮಿಷನ್ ಆದ್ಮೇಲೆ ದುಡ್ಡು ಕೊಡೋದು, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಡೋದು ಅಂತಿದೆ ಕಂಡೀಷನ್ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ. 2 ದಿವಸದಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಬಂತ, ಏನಾಯ್ತಂತ ಅದು ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ? ಹೌ 2 days ಅಗ್ರಿಮೆಂಟ್ ಆಗಿ 2 days, ಹೌ ಅರ್ಜೆನ್ಸಿ ಜನರೇಟೆಡ್? ವೈ ಡೆತ್, ಡಿಮೈಸ್, ಅದೇನೋ ಒಂದು ಸ್ಟ್ರೋಕ್ ಆಯ್ತು, ಒಂದು ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಯ್ತು, ಹಂಗಾಗಿ ಇಮಿಡಿಯೇಟ್ಲಿ ದುಡ್ಡು ಬೇಕಾಯ್ತು. ವೇರ್ ಆರ್ ದೋಸ್ ಫ್ಯಾಕ್ಟರ್ಸ್?
They are in crisis.
ಅದ ಅಂತ ನೀವು ನಿಮ್ ಮಂತ್ರ ಅದು, ಕ್ರೈಸಿಸ್ ಅನ್ನೋದು. ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಟ್ರೂತ್ಫುಲ್ ಬೇಕಲ್ಲ. ಹೌ ವಾಟ್ ರೀಸನೇಬಲ್ ಎನ್ಕ್ವೈರೀಸ್ ಯು ಡಿಡ್? ಹಿಂಗಾಗಿದೆ, ಏನಮ್ಮ ಇದು ಮೊನ್ನೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿನಿ, ಈಗ ಮತ್ತೆ ನಾಳೆ ನಾಡ್ದು 2 ದಿವಸ ಆಗಿಲ್ಲ, ದುಡ್ಡು ಕೇಳಕ್ ಬಂದಿಯಾ, ಯಾಕೆ, ಏನಂತದ್ದು ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿ ಕೇಳಿರಪ್ಪ. ವೇರ್ ಹ್ಯಾವ್ ಯು ಆಸ್ಕ್ಡ್? ಏನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇದೆ? ವಿದಿನ್ 2 days all of a sudden what urgency began in the family? ಆಗ್ಬೋದಂತ, ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಗ್ತದೆ, ಅರ್ಜೆಂಟ್ಲಿ ಒಂದು ಮಕ್ಳು ಮ್ಯಾರೇಜ್ ಫಿಕ್ಸ್ ಆಗ್ತದೆ, ಏನೋ ಒಂದು ಅಂತದ್ದು ಏನಾರ ಬೇಕಲ್ಲ, ಅಂತದ್ದು ಏನಿಲ್ಲ. ರೆಫರ್ ಆಗಿಲ್ಲ. ಅದೇನಾಗ್ತದೆ, ಆಲ್ ಇಟ್ ಈಸ್ ಎ ಜಾತ್ರಾ ಆಫ್ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಲಾಯರ್ಸ್. ಇಟ್ಸ್ ಎ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಲಾಯರ್ಸ್ ಗಳ ಸಂತೆ. ಅಲ್ಲಿ ಜಸ್ಟಿಸ್ ಕಳೆದು ಹೋಗ್ಬಿಡ್ತದೆ, ಓದಿ ಬರೆದು ಮಾಡಿ ಕಷ್ಟಪಟ್ಟು. ದುಡ್ಡಿಸ್ಕೊಂಡಿಯಪ್ಪ ಅಂತ.
Between 2008 exhibit P1 and the legal notice exhibit T5 2011, 3 years.
Yes, ma'am.
What have you done?
No, there was a bar to
ಅದ್ರ ಬಗ್ಗೆ ನೀವೇನಾದ್ರು ಕೇಳಿದ್ರಾ? ಏನ್ ಮಾಡಿದ್ರಿ?
ಪರ್ಮಿಷನ್ ತಗೊಂಡ್ಯಾ?
Directly in the reply, I have stated that ನೀವಿನ್ನ ಅದು ಪರ್ಮಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಥವಾ ಡೇಟ್ ಎಕ್ಸ್ಪೈರಿ ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಇವಾಗ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
GPA ನಲ್ಲಿ ಅವರೇ ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂತ ಕಂಡೀಷನ್ ಇರೋದು.
T5 ನಂತರ ಅದು.
ಹೌದು,
3 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ ಅಂತ ಪ್ರಶ್ನೆ
ನಾವು ಕೇಳ್ಬೇಕಾಗಿಲ್ಲ.
ರೆಕಾರ್ಡ್.
Read this. Kodi. How bank account is opened? Think of account. There should be a person who should identify, and they should be convinced that the bank account is required and is a genuine bona fide customer. Read loudly. Many students will be sitting here, young lawyers will be sitting here. They will know. At least we will know.
Opening of a new account. Letters of introduction or reference. Before opening a new account, a banker should take certain precautions and must ascertain by inquiring from the person wishing to open the account. If such person is unknown to the banker as to his profession or trade as well as the nature of the account he proposes to open, by making necessary inquiries from the references furnished by the new customer, the banker can easily verify such information and judge whether or not the person wishing to open an account is a desirable customer.
ಅದೆಲ್ಲ ಹಾಕೊಂಡ ಮೇಲೆ ಅಕೌಂಟ್ ಓಪನ್ ಆಗ್ತದೆ. ಆಮೇಲೆ ಒಬ್ರು ಐಡೆಂಟಿಫೈ ಮಾಡಬೇಕು, ಇಲ್ಲ ಬೊನಾಫೈಡೆ ಅನ್ಕೊಂಡು ಅದಾದ್ಮೇಲೆ ಆಗ್ತದೆ ಅಂತ ಬರೀತಾನೆ ಟೆನ್ನನ್. ಟೆನ್ನನ್ is an authority on banking law. At least half a dozen judgments of the Supreme Court refer to this author. Even 2 days, the urgency generated. What marriage fix ಆಗಿಲ್ಲ, stroke ಆಗಿಲ್ಲ, heart attack ಆಗಿಲ್ಲ, ಅದು ಏನಿಲ್ಲ. 2 days. Number 3, when there is a requirement for permission, he is not some ordinary man, he is MBA. Without getting the permission, how he would give this so much amount? Much more than what our eyes are doing.
There's definitely, and there's definitely much more than meets the eye in this transaction for sure.
Yes, ma'am.
You know,
An immobile property transaction, you've retained the property. Matters being heard. Before we arrive at the thing, one opportunity, if you all can amicably resolve the matter. If you all want to take.
ನೀವು 5 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದಕ್ಕೂ ನಿಜ ಇದೆ, ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟು
ಕಳ್ಸ್ಬಿಡ್ತೀನಿ, ಅದು ಕೊಡ್ತೀನಿ, ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತೀನಿ ನಾನು.
Whatever, ಅದು, see, you all know what actually transpired.
Yes, ma'am.
ಗೊತ್ತಿರುತ್ತೆ ನಿಮ್ಗಂದ್ರೆ ನಿಮ್ ಪಾರ್ಟಿ
ಟ್ರೂತ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ತಾ ಇಲ್ಲ. ಏನು ನಾವೇನು ಜಗ್ಲರಿ ಮಾಡಿದ್ರು ಸಮಥಿಂಗ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ವಾಟ್ ಈಸ್ ದಟ್ ಹ್ಯಾಪನ್ಡ್ ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
So, madam, I have offered.
ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ವೆರಿ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಎಡ್ವೊಕಸಿ ಹ್ಯಾಸ್ ಎಂಟರ್ಡ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಎಟ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅನ್ನೋದು ಬಿಟ್ರೆ ಮುಂದಿನ ಸರಿಯಾಗಿ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ನೀವೇನು ಆಫರ್ ಮಾಡಿದ್ರಿ?
I have offered my lord to comply with the trial court order because what happened to with that DD amount 14 lakhs? ನನ್ನ ಹತ್ರನೂ ಇಲ್ಲ ಅದು ದುಡ್ಡು. ನಾನು DD ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ನನ್ನಿದು. ನನಗೂ
ಗೊತ್ತಿರುತ್ತೆ ಯಾರ ಕೈಗೆ ಹೋಗಿದೆ ಅಂತ.
14 lakhs ನೀವೇ ಡಿಡಿ ಬೈ ಮಾಡಿರಲ್ಲ?
ಇಲ್ಲ, ಅವ್ರ ಕೈಗೆ ಕೊಟ್ಟಿರೋದು.
ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ಅಲ್ಲ, ಎಲ್ಲಿಗೆ ಹೋಗಿದೆ ಅಂತಾನು ಏನೋ.
I am also surprised. ಈಗ ಅವ್ರು
ಏನೋ ಒಂದು ಕ್ಲೂ ಇರುತ್ತೆ,
ಏನಾಗಿದೆ, ಯಾರು ನಡುವಿನವ್ರು, ಯಾರು
ಗೊತ್ತಿರ್ಬೋದು, ಬಟ್ ಬಿಟ್ವೀನ್ ಯು ಆಲ್ ನೋ ವಾಟ್ ಹ್ಯಾಪನ್ ಟು ದಟ್ ಮನಿ.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಲ್ಲ. ಇಷ್ಟು ಅಮೌಂಟ್ ಆಗಿದೆ, ನಿಮ್ಮ ಮಗನೂ ಸಹಿತ ಬರೀ ಎಜುಕೇಟೆಡ್ ಇದ್ದಾನು.
ಅಲ್ಲ, ನಿಮ್ ಕೈಯಿಂದ ಹೋಗಿದೆ, ಅವ್ರ ಕೈಗೆ ಮುಟ್ಟಿಲ್ಲ.
ಅಲ್ಲಿ
That is the suspense.
ಅಕೌಂಟ್ ಇದೆ, ಆ ದುಡ್ಡು ಬಂದಿರೋದು ಇಲ್ಲ, ಎದ್ದದು ಇಲ್ಲ. ಆಂಧ್ರ ಬ್ಯಾಂಕ್ ನಲ್ಲೂ ನಮ್ ಬ್ಯಾಂಕ್ ಆಂಧ್ರ ಲಕ್ಷ್ಮಿ ಕೇಳಿಸಿ ಎಕ್ಸಿಬಿಟ್ ಓಪನಿಂಗ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ 0 ಇದೆ. ಅಟ್ ಲೀಸ್ಟ್ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ಇಂದ ನನ್ ಈ ಅಕೌಂಟ್ ಗಾದ್ರೂ ಬರ್ಬೇಕಲ್ಲ ದುಡ್ಡು, ಅದು ಬಂದಿಲ್ಲ, ಕ್ರೆಡಿಟ್ ಆಗಿಲ್ಲ. ಲಕ್ಷ್ಮಿ ಕೇಳಿಸಿ
ಅಲ್ಲಿ ಬರೋದೇ ಆ ಅಕೌಂಟಿಗೆ ಹೋಗೋದೇ, ಆ ಅಕೌಂಟಿಗೆ ಹೋಗಿ ಆ ಅಕೌಂಟ್ ಫಾರ್ಮ್ ನಲ್ಲಿ ಮೊದ್ಲಿನ ಅಕೌಂಟ್ ಇವ್ರ ಅಕೌಂಟ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿಲ್ಲ. ಅಲ್ಲೊಂದು ಕಾಲಮ್ ಇದೆ, ಬೇರೆ ಬ್ಯಾಂಕಿನಲ್ಲಿ ನಿಮ್ಮ ಅಕೌಂಟ್ ಇದೆಯಾ ಅಂತ ಕಾಲಮ್ ಇದೆ, ಬ್ಲಾಂಕ್. Yes, such things could happen only in Alice in Wonderland.
ಎಕ್ಸಿಬಿಟ್ P7 ಅಲ್ಲಿ ಇದೆ ಅಮೌಂಟ್. ತಾವು ನೋಡ್ತಾ ಇರೋದು ಎಕ್ಸಿಬಿಟ್ 9 ಕಂಟಿನ್ಯೂಯೇಷನ್ P7 ಅಲ್ಲಿ ಇದೆ ಅಮೌಂಟ್ ರಿಪ್ಲೇಸ್.
ನೋಡಿ, ಏನಾದ್ರು ಅಮಿಕೇಬಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಕೊಳ್ಳಂಗಿದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ನಮ್ಗೆ ಬಿಡಿ, ನಮ್ ತಲೆಯಲ್ಲಿ ಬಂದಂಗೆ ಬರೆದು ಹಾಕ್ತೇವೆ ಅಂತದ. ಏನು
Beginning itself, I have offered my lord.
ಏನಂತ?
As on the date of agreement, the property worth rupees 50 lakhs totally. Your lordship well aware that nobody will show the entire sale consideration to avoid the stamp duty. This is the fact going on. As on today, the property is worth 1.5 crore. On that day, I have invested this 31 lakhs something. Today, if they have paid with interest 12%, justice will be ended to both. This is my submission.
ಪ್ರಾಪರ್ಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೇನೆ.
Property, let them property be there.
ಪ್ರೆಸೆಂಟ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಬಿಡ್ತೀನಿ ನಾನು ಪ್ರಾಪರ್ಟಿ. ಅದೇನು
ಅಗ್ರಿಮೆಂಟ್
Present market value sale ಮಾಡ್ಬಿಟ್ಟು
ಅವಾಗ ಸೇಲ್ ಡೀಡ್ ಸೇಲ್ ಯಾವಾಗ ಮಾಡ್ಕೊಂಡು ಅದು ಸಂಬಂಧಪಡ್ತದೆ. ಅಂದ್ರೆ ಹೊಸ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಳ್ರಿ, ನಾವು ಬರೆಯಕ್ ಬರಲ್ಲ, ನೀವು ಬರೆಯಕ್ ಮೊದ್ಲೇನ್ ಅಗ್ರಿಮೆಂಟ್ ಅದೇ ಸಂಬಂಧಪಡಲ್ಲ. ಯಾಕಂದ್ರೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಇಸ್ಕೊಂಡು ಇದು ಒಪ್ಕೊಂಡ್ರ ಆಲ್ರೆಡಿ.
5 ಲಕ್ಷ ರೂಪಾಯಿ ಐ ಕಾಂಟ್.
Yes, you have admitted.
I can deny.
ಬಿಡಿ ಇವಾಗ. ಹಾಗಾಗಿ ಅಗ್ರಿಮೆಂಟ್ ಬಗ್ಗೆ ಡೌಟ್ ಇಲ್ಲ. Agreed to sell the property. Question is whether that 14 lakhs etc. is paid to you or not. ಅದ್ರ ಮೇಲೆ ಡೌಟ್
ಅಷ್ಟೇ.
ಆ ಅಮೌಂಟ್ ಪೇಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳ್ಬೋಣ. Can think of that also. After all, if assuming that she has not received that money, so we can make that arrangement also, because there is an agreement. There is an agreement to sell.
ಒಪ್ಕೊಳ್ತೀವಿ. There is no denial. Sorry.
Again, only the doubt arises only with respect to that DD he having bought it, credited to account and some amount drawn from that particular account. ಅದನ್ನ ಬಿಟ್ಕೊಂಡ್ರೆ rest of the thing is genuine document.
ಒಪ್ಕೊಂಡಿದ್ದೀವಿ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ I have not denying.
You can't say ಇವತ್ತಿನ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಹೇಳೋದು. It will be a fraud on the buyer, to say the least. Admitted the agreement, admitted receipt of 5 lakhs. Only the subsequent, and for that we can make so many arguments. Not alike. Not that I want to retain the land and do it. But he's admitted. Yes. ನಿಮ್ಗೊಂದು ಆಪ್ಷನ್ ಕೊಡ್ತೀವಿ, ಹೋಗಿ ತುಂಬಾ ನೆರಳಿರುವಂತಹ ಒಂದು ಕೋರ್ಟದ ಪ್ರಿಮೈಜಿಸ್ ನಲ್ಲಿ ಗಿಡಗಳಿದಾವು, ಆ ನೆರಳಲ್ಲಿ ಕುತ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ರಿಪೋರ್ಟ್ ಮಾಡಿ, ರಿಪೋರ್ಟ್ 1 ವೀಕ್ ಟೈಮ್ ಕೊಡ್ತೇವೆ ನಿಮ್ಗೆ. ನಾವು ರಿಸರ್ವ್ ಮಾಡ್ತೀವಿ. ನೀವು ಅಕಸ್ಮಾತ್ ಅಮಿಕೇಬಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಅಂದ್ರೆ ಬಂದ್ ರಿಪೋರ್ಟ್ ಮಾಡಿ, we'll recall that order. Otherwise, whatever order we want to pass, we'll pass. That's all. ಅಷ್ಟೇ.
Settlement was failed. I will leave it to your lordship. Orders may have passed. They have tried so many times.
ಅದಾಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. ನಾನೇ NOC ಕೊಟ್ಟಿದ್ದೆ, NOC ಕೊಟ್ಟಿದ್ದೆ, ಮತ್ತೆ ನಾನೇ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು ಸಬ್ಜೆಕ್ಟ್ ರಾಘವೇಂದ್ರ ಅಂತ ಬರ್ಬೋದು. ಅಲ್ಲಿ ನನ್ನ ನೇಮ್ ಇರ್ಬೇಕಲ್ಲಿ. ಎರಡು ನಾನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ RFA ನನ್ನ ನೇಮ್. ನಾನು ಹೌದು.
After 1 week.
Lastly, may I refer on judgment?
In proposition.
Proposition, my lord, how the frauds are going in the real estate business. Court, how to
Approach the.
yes, my lord. Recent Supreme Court judgment. Second page, my lord. In cases like the one before us, it is not for us to just mechanically analyze the contentious transaction, but also ensure that justice is remedied and nobody is benefited by their own wrongs. Here, wrongs may be found both the parties. What your lordship observed that reading is not in the proper way. They are saying that we are ignorance of opening of the account. They have not taken any action. In this case, my lord, the fact is that, my lord, A executes sale deed in favor of B, my lord. That document was kept for pending due to non-payment of stamp duty, my lord. That is in the year 1985. Thereafter, the vendor died, purchaser has died, my lord. After a lapse of 26
years.
Yes, my lord,
They
26
got
years,
this.
executed the sale deed, my lord. And in the meanwhile, this vendor executed another sale to the third party, my lord. Therefore, the Supreme Court held that
the sale consideration has not been passed on, then it is null and void. This is judgment of the
So Justice Woka's judgment. That is referred to larger bench now. Because Mullah has quoted 3 judgments of various high courts, saying that non-payment of Mullah is Transfer of Property Act Mullah Kodi. Non-passing of consideration is no ground for invalidation of the sale deed.
yes,
It can be a ground for a suit to recover the money. That's how Mullah discusses.
Even
So matter is referred to the larger bench.
2009 there is a judgment of the Honorable Supreme Court.
Adu nudam idu nullum pactum. Suppose if there is no consideration at all, that is one thing. There is consideration, but it has not passed to the vendor is another case.
Yes.
That was considered in this case by Justice Oka.
There-
This is in a reference now before the larger bench.
The Lordship says that page number,
Because
para
the sale- the
33.6.
The present sale
Have
deed,
referred the judgment.
present sale deed.
Consideration ಇದೆ ಅಲ್ಲ, 5 lakhs ಇದೆ ಅಲ್ಲ.
Sale consideration has been shown.
Whole consideration ಅಂದ್ರೆ
ಅಲ್ಲ 57 lakh ಅಂತ ಹೇಳ್ತಾರೆ. There is no reference in the sale deed either to the agreement or to exhibit P4. Plasma credit is in exhibit P3. There is no reference to the agreement.
No,
There is
that's
no
all right. But agreement as such is not in dispute.
Not in this.
Receipt of money is not in dispute.
Yes.
How can you say that there is no consideration?
Agreement ನಲ್ಲಿ ಇರೋದು 36 and lakh. Sale consideration 57 lakhs. And it has not been paid to me because the power of attorney has executed in his favor only.
Read definition of sale under section 54. What is
ಅದನ್ನೇ interpreting that my lord, it should
54.
be against the price.
Price paid or promised, partly paid or promised. These are the words. Section 54.
Just minute. That is extracted here in this.
That's all. That was a case where not even a rupee had changed the hands.
Yes.
But here is a case where you have admitted receipt of rupees 5 lakh. Read 54. ಕೊಡಿ.
Sale is a transfer of
ಅವ್ರಿಗೆ
ownership in exchange for a price paid or promised or
Paid or promised.
part promised.
Part promised also. That's how English people have drafted the Transfer of Property Act.
They should have been challenged that sale deed, man. Sale deed has not been challenged. There is a finding, ನಾನು ಕೊಟ್ಟಿದ್ದ judgment ಅಲ್ಲಿ, there is a finding that they should have been challenged it.
Fraud, fabrication, duplicity. Yes.
Till today, that sale deed is alive, man. Much of.
Justice Vasant Kumar's judgment is,
Prabhu ಇದೆ. ಅವ್ರದ್ದು ಇದೆ.
Justice Vasant Kumar's judgment is ILR 1993 Karnataka.
Correct, correct. Under Power of Attorney Act it is. Under Power of Attorney Act.
The question was whether a managing director of a company is a mere employee or an agent, then they go into each aspect of agents. Sitting
No,
with
not
Justice
that.
Shiv Shankar.
Justice Shiv Shankar Bhatt and Vasant Kumar ಅದು.
That's it.
Correct. ಅದೊಂದು ಪಡಿ, ಅದೊಂದು ಬರ್ತೀವಿ.
2558.
ಇದೆ, ಇದೆ.
255.
ಅವ್ರಿಗೆ ಲೆಕ್ಕ ಒಂದು read ಅನ್ನೋದು ಓದಂಗ್ ಬರ್ತಾರಲ್ಲ, ಅದಕ್ಕೆ ಸಿಟ್ಟು ಬರ್ತದೆ ನನಗೆ ಅಷ್ಟೇ. They don't read any standard book on pleadings at all. Pleadings ಮೇಲೆ ಒಳ್ಳೊಳ್ಳೆ ಪುಸ್ತಕ ಓದ್ಕೋಬೇಕು. ಅವಾಗ ಹೆಂಗ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಮಾಡ್ಬೇಕು, ಹೆಂಗ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು ಎಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ. ಅದರ್ವೈಸ್ ಅಂತ ಎಲ್ಲ ಸಬ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್. ಎಸ್. Yes.
But on the last date of hearing, your lordships were pleased to observe that identity of the property was in question, and your lordship was pleased to ask the plaintiff's advocate to identify where this suit 1409A, respect of which they have filed two suits, can be identified. Is it included in the layout plan approved by BDA? That is what the claim, partly approved or not approved. If
ಅಲ್ಲಿ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡುವಾಗ ರೋಡ್ ಟು ದಿ ನಾರ್ತ್ ಅಥವಾ ಈಸ್ಟ್ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು. ರೋಡ್ ಅಂತ ಹೇಳೋ ಬದ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಹೇಳ್ಬಿಟ್ರು.
ನೆಕ್ಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಹೇಳಿದ್ದಾರೆ. ನಾರ್ತ್ದು there is a in the two suits, my lord, the boundaries as far as east and north are differently mentioned in the 15/2/53 of 2005.
ಅದು ಒಂದು ನಿಮಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನಾವು ಹೇಳಿದ್ದು ಜಸ್ಟಿಸ್ ಸ್ವಾಮಿ ಅವರ ಪ್ಯಾರಾಮೌಂಟ್ ಇಂಡಸ್ಟ್ರೀಸ್ ಓದ್ಕೊಂಡ್ ಬರಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ. ಆಮೇಲೆ ಜಸ್ಟಿಸ್ ಉಳ್ಳಾಳ್ ಅವರ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಓದ್ಕೊಂಡ್ ಆರ್ಡರ್ 21 ರೂಲ್ 103, 104 ಮೇಲೆ ಇರುವಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು. ಅವ್ನ್ ತಗೊಂಡ್ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು.
This division bench, my lord, directed by Justice K. Swami, my lord.
Yes.
As it then was ILR 1991 Karnataka.
ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಇಲ್ಲಿ 2197 ನಿಮ್ಮ ಅಬ್ಸ್ಟ್ರಕ್ಟಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡುವಾಗ ಅಲ್ಲಿ ಈಗಾಗಲೇ ಸೂಟ್ ಇದೆ, ಅದನ್ನ ಇದನ್ನೆಲ್ಲ ಡಿಸೈಡ್ ಮಾಡಿಕೊಳ್ರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಹಂಗಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಫ್ ಮಿಸ್ಟರ್ ಶಂಕರ್ ರೆಡ್ಡಿ ಅದರ್ ಡೇ ದಟ್ ಮ್ಯಾಟರ್ ಈಸ್ ಕನ್ಕ್ಲೂಡೆಡ್ ಅಂತ ಹೇಳೋದನ್ನ ಒಪ್ಪಕ್ಕಾಗಲ್ಲ. We can't agree with that because nothing is concluded. The court itself said, go and fight before the pending suit ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
That is what, my lord,
Swami says, that Paramount Industry says.
And even in the order, my lord, passed in one suit on IA, my lord, Judge Kunna, my lord, as he then was, he said that properties are different and it is yet to be proved.
ಅದೆಲ್ಲಿದೆ?
ಅದು Kunna ಅವರ judgment. That is, my lord, passed on.
ಇದರಲ್ಲೇ
ಇದೇ ಸೂಟ್ನಲ್ಲಿ
ಎಲ್ಲಿದೆ? ಆ ಕ್ವಶನ್ ಯಾಕೆ ಹೇಳ್ತು?
My lord, exhibit D23. Study the suit.
Page number
954 minutes.
Volume 2.
Volume 2.
3. Sorry. There is already a finding. Properties are different and the finding idea.
That is what 953. Exhibit, it is marked as exhibit D.
954.
954. My lord, this is an order on IA.
This 1 and 2 idu. These are all interlocutory orders.
Relevant, my lord.
How? In deciding suits, orders made under order 39 and 1 and 2 cannot be looked into at the judgment idavu. When it comes to identity of the property, what is said need not be looked into.
965 nalli this is what observed and it is confirmed. 965. But after quoting, my lord, the judgments in para 12, para 13, my lord, there cannot be any disagreement with the principle laid down in the above decision. But in the instant case, what is important to be noted is that the plaintiff has come before the court alleging that he is the absolute owner in possession of the suit schedule property, 14 RTL. But the very document produced by the plaintiff go to show that the plaintiff has not derived complete and absolute title in respect of the suit property.
Ideng nodadu, idu nodlikke baralla.
Then this I, your lordship, only to hold up the argument that even in the trial, my lords, they have not established the fact that, my lord, what they say, how they describe the suit schedule property, my lord, in their plain, but in this kindly first volume, how they describe the property as page 14 in RFA, first volume, 885. There is
Schedule A, Schedule B.
Schedule B, B and C, that is gift deed is B and C. A na, all that piece and parcel of the site bearing number 14 A, overwritten as number 1928 CMC Kata. But it presupposes when they describe the property in that way, but the property number 1409A must have been in existence. Must have been in existence. That is overwritten. Overwritten means covering above, on top of it, overwritten. But this is slightly, my lord, described in a different way in the other suit filed by the 30 to 35. The other 684 nalli page 10 nalli, kindly see the difference how parties are same. The plaintiff in OS number 32, 35, not is plaintiff number 4 minutes in the other suit. Plaintiff 5, here he files this suit earlier.
Page number?
Other suit, all that piece and parcel.
There are two suits.
Page number yadu?
Other 10 minute plain copy. The other idherly 684.
ಇನ್ನೊಂದು ಅವ್ರದ್ದು.
ಇಲ್ಲ ಇದು ಎರಡೂನು ನಮ್ದೇ. ಎರಡೂ ನಮ್ದೇ.
There are two sets of paper books.
But first minute this M. Nagaraj, who is plaintiff number 6 minute in the other suit, that is 15 to 53, he files similar 32, 35, 2004 earlier. Against
ಅದರಲ್ಲಿ description ಬೇರೆ ಇದೆ.
Description property adene in the bracket they say is wrongly claimed as site number 1928 F in the layout formed by the judicial society. Again, my lords, adaralli overwritten, illi wrongly claimed. There is a difference.
ಈ ಐಡೆಂಟಿಟಿ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಇಶ್ಯೂ ಏನಂತ ಇದೆ ಅದರಲ್ಲಿ ಅವರೇಟ್ನ ಶೋ ದಟ್ ಇಶ್ಯೂ.
Issue minutes. This suit, if your lordship is having 684, but issue is but judgment minute starts in this volume at page 323, but issue.
What is the issue? What is the evidence?
336. 684 of 2009 innally. Same judge.
Page number?
Issues are mirrored at page 40, but we can find out from the judgment itself.
That's what.
336 in the issues are para 5. Lordship one.
336.
336. Internal page 14, para 5.
That he is in lawful possession of suit scheduled property.
Property.
Defendants
Issue-
are interfering with
plaintiff proves that he is in
plaintiff is
lawful
entitled to the
possession of-
injunction
Because
prayed
prayer
for.
was whether the plaintiff further proves that the defendants are interfering with this, that both does not survive, that is the finding, whether the plaintiff is entitled to the injunction prayed for. Additional issue.
Issues.
They are different.
This is the property in little. So, issue as to the identity of the property is not framed.
Not framed.
What do you,
Though
14.5?
very, my lord, in the written statement, very categorical statement is taken. The different is nothing to do with 1409A. It does not belong to me. Society has allotted, that is a matter between the society and the plaintiffs.
No,
Because and
any one
in
of
a
you could have
compromise
moved-
petition,
Any one of you could have moved order 14 rule 5
very
application.
existence of the property is disputed, very identity of the property is also questioned.
Eಲ್ಲಿ dispute ಆಗಿದೆ. Identity of the property ಬಗ್ಗೆ dispute
Written statement ನಲ್ಲಿ,
ತೋರ್ಸಿ.
written statement ನಲ್ಲಿ,
ತೋರ್ಸಿ.
take volume one.
885, RFA 885, volume 1.
RFA 885 ದಲ್ಲಿ ಇದೆಯಾ? Volume 1.
Volume one ನಲ್ಲಿ. That is.
Page number?
Page number 17. Paragraph 3.
There are two also maybe. Same. In this particular case, this. There are two also.
Not like that. You add one over here. E number. Why you did not move any application under order 14 rule 5 seeking identity of the issue is in crisis? That question arises now. Therefore, frame issue as to the identity.
Issue as to the identification.
And what is the stand of the society? What is the stand of the society as to the number of?
Lord, they have filed written statement, my lord. Please notice it.
Page?
Lord, it is that page. $31, man.
Paragraph 16.
Sorry, my lord, sorry.
It cannot be 31.
Pen number 3 is it, society?
Yes, 3 is the society, my lord.
In which
Uh,
next appeal. The connected appeal. Corrected appeal. So that is in RSA 84. Please. Injunction suit. Please. The declaration Davada society party ilva? We are not made as party.
Declaration is not a party in the declaration.
No, doesn't matter.
Since both the suits were pending before two different courts, there was an order passed by the principal court.
Go to one court.
To one court.
Actually, injunction suit society.
Please.
The declaration suit is
Society.
What is the stand? Because in some form, both of them somehow claim through the society.
Society only.
Not.
Both claim under the society.
Joining or develop ಮಾಡುವಾಗ ಪಕ್ಕದಲ್ಲೂ ಮಾಡ್ಬಿಟ್ರು
Not what happened was.
ಅಲ್ಲ 98/7 98/2 ಅಂತ ತಿಳ್ಕೊಂಡು ಡೆವಲಪ್ ಮಾಡ್ಬಿಟ್ರು ಅಂತ.
Not 98/7 is our land. Not it measures 1 acre 7 guntas. Not my land was not was not part of the acquisition proceedings. However, my lord, certain sites were sought to be carved out at that particular point of time. My lord, at the time of carving out the sites, my lord, some of the judicial officers, some of the district judges were allotted sites in my survey number. I filed a suit, my lord, against the allottee saying that my land is not acquired. Please do not put up any construction.
Who are you?
Not, I represent the plaintiffs.
You are the original owner of the property.
Original owner of survey number 98/7.
Under whom both society and Mr. Devdas also claim.
They claim 98/2.
98/2.
Mine is 98/7.
Perhaps at one particular point, it was only 98. It's a pod.
Not, but.
It must be a pod only. It cannot be anything else. Correct. But 98 belonged to one owner first.
Please, that would be about 40, 50 years earlier to that.
Okay.
Thereafter, my lord, when I file a suit against the judicial officers, my lord, were allotted sites in my land, the society called upon me to enter into a settlement. You give up your rights over 1 acre 7 guntas of land. We will not give you any compensation. We will give you alternative sites which have not been allotted to anyone else, which still remains in the society.
Those 4 sites.
Those 4 sites. At that particular point of time, my lord.
For 3 sites, there is no dispute.
There is no dispute, my lord. The records have been entered in my name. I have put up construction. I am residing therein. Insofar as this particular property is concerned, my lord, it so happens that adjacent to this 98, the property that has been allotted, the 4th site, the defendant, that is the appellant before this court, not also owned certain portion of land next to this particular property.
Adjoining property.
Adjoining property.
Adjoining to item number 4.
Item number 4.
Then the issue arose whether it has already been allotted to anyone else, this particular fourth site. Society, my lord, said, we have not yet allotted to anyone else. Therefore, my lord, we enter into a compromise petition. Compromise decree has been formed, it has been passed, accepted by the court. Thereafter, my lord, at the time of execution of the sale deed,
If it was a compromise decree, why at all it was put to execution at the territory?
that the reason being, not if
Now, one more. Even this compromise decree, issue as to the identity again is reflected there.
1409 bar A is now the issue.
now the issue,
The other three sites are not there.
please, my lord.
The defendant is the neighboring owner of 1409 bar A.
Please,
Fourth
my lord.
side, fourth
Fourth
side.
side. He claims to, is the
He
defendant.
claims in lieu of that particular portion of the land which belonged to him, which is adjacent, which has been utilized for road. Alternatively, this particular very same site has been given with a different number.
Essentially, defendant also claims to be an allottee from the society.
Allotted from the society, both parties,
Both are-
Stand of the society.
society.
So what the society would say?
Society
That will
says, we have not given
No,
any
no,
such.
learned senior advocate is also here.
Not appearing for the society.
You are not, you appear for whom?
My lord, I appear for Munivirana, my lord,
That,
the
that,
original owner. My lord,
my lord,
I'm
I,
just,
I appear in one of the appeals. My
Only
learned
brief
friend appears-
facts I'll say. Only one, 2 minutes. my lord.
Yes.
See, notice this, my lord. Just a small synopsis.
Why 2 minutes? We will give you sufficient time.
No, my lord, preliminary, let my learned senior finish it, my lord. Thereafter, I'll add. Just a brief background.
Tax return. My friend is an expert.
We treat him as an authority on taxation.
That's why I said that fashion only is prepared.
My lord, please notice at the first page, my lord. 98/7 was owned by Munivirana and his children, my lord. It was a HUF property. Next to it.
1 acre, 7 guntas.
Yes, my lord. Next to it was Gopi's, my lord, 98/3 or 98/2, my lord, my subject to correction, my lord. That is 28 guntas. That is 30,000 square feet, my lord. This is again 51,148 square feet. Please, my lord.
98/7.
Yes, my lord. Both entered into litigation, my lord. In respect, society filed specific performance suits in respect of both the parties, Munivirana and Gopi and his.
They were also parties.
Yeah, that is separate suits, my lord.
Separate.
Separate suits where compromise was or entered into.
In compromise was in which suit?
In both the suits,
Both the
their suit and our suit.
OS
I'll
number.
give it, my lord. It is the next page is the OS number. I'll give it, my lord. Second page is their suit.
28 and 2019.
Third page is our suits, my lord. Now, please notice again the first page, my lord. 1 minute. My lord, in this is the sites allotted to us where sale deeds have been executed, my lord. 1, 2, 3, 4. That is 27 square feet has been allotted to us, my lord, out of 51 which has been taken possession of. Whereas they were given, my lord, 32 square feet after taking 30,000 square feet as possession, my lord. These are all documents which have been marked.
Can you please repeat what you just said?
Last sentence.
Sorry, my lord, sorry. My lord, please notice the left side, my lord. Left side is the exchange which took place between the society and my client, my lord, Munivirana. Now, please notice, my lord, in the second column, exhibit P61, that is 51,183 square feet, my lord. Your lordship got it, man? In the brackets, my lord, second column, 98/7, 1 acre, 7 guntas.
51,183 square feet.
That is the amount which they took, my lord.
No, that's the extent of land.
That is the extent, sorry, my lord. The extent of land they have taken over. Extent of land, my lord. Please, my lord, thereafter, my lord, in exchange, they gave us 27,476 square feet, my lord. This is by virtue of a deed, my lord.
Correct.
That is exchange.
Correct. 4 ಸೇರಿಕೊಂಡು ಇದನ್ನ ಇಟ್ಕೊಂಡು ಇದು 4 ಕೊಟ್ಟ. We have problem only with 1409 now.
Yes, my lord. Now, please notice on the right hand side, my lord. Similarly, they gave up 30,492 square feet.
98/3.
Yes, my lord. 28 guntas. Now, out of that, they were already exchanged under a judgment and decree, my lord, in a compromise.
Just he's explaining that. Let us.
In a compromise, my lord, they've already given 32,620 square feet, my lord. They've got the entire thing in exchange.
Wrong description.
What they got in exchange?
32, these sites, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9 sites they got, my lord. Right side.
Square feet. And 492 is 60,000. Correct. ಈ exhibits ನೋಡಿಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡಕ್ಕೆ ಈ ಎಕ್ಸಿಬಿಟ್ಸ್ ನೋಡಿದ್ರೆ ಏನ್ ಇಂಪ್ರೆಷನ್, ಈ ಇಂಪ್ರೆಷನ್ ಯಾವ್ದಾರು ಹಾಕೋದು ತಿಳಿಲ್ಲ. ನೋಡಿಬಿಟ್ಟು ಮುಗಿದ್ಬೋದು ಸ್ವಲ್ಪ.
My lord, thereafter, my lord, I'm sorry, my lord, if I am keeping your lordship.
No problem. No problem. We have a small function.
Please, my lord, your lordship matter, I'll continue some other time, whenever your lordship.
Give a copy.
Share that copy.
I'll share it.
Sharing, but let him-
Very, in a very appreciably crisp way he has done that.
no problem.
ನೀವು ಈ ರೀತಿ ಒಂದು ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
No problem in
That
sharing.
also helps.
Really? TDS ಹೊರಟು. But my only request to my learned senior is, let him again check up the fact.
Yes, man, I'll check up.
Very
That is
wrong
his version.
description, Papa. But I don't like to right now expose him. Plus, let him reach. Let him not make even a small error, my lord, on fact.
But one thing that lurks in our mind is why you did not move application, anybody, under 14(5), under order 14 rule 5, you could have moved the application
Both
saying
sides-
that
both sides
about
could.
the identity of the property, there is an issue going by the pleadings of the parties. Therefore, frame an issue. That would have eased the task to a great extent.
It is true, my lord, but what happened was.
Each others
subsequently-
understood the case.
Yes, my lord, I'll produce evidence to show that. My lord, it went up to the.
They went to the trial with knowledge
Yes, my
that
lord,
these are the things.
what has happened?
One submission I would like to make, not. Insofar as identity is concerned, when he files an obstruction application before the executing court, that is already been determined.
Obstruction ದಲ್ಲಿ ಏನ್ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ ನೋಡಿದೆ ನಾನು.
Not there are two,
Obstruction ನಲ್ಲಿ
there are two orders.
matter is being litigated in a suit, you work out your remedy there ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಹಂಗಾಗಿ ಫೈನಾಲಿಟಿ ಬರ್ಲಿಲ್ಲ.
But what happened was, at that particular point,
ನೀವು ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ರೆ that becomes easy.
because the two execution orders were there, my lord. The first order that your lordship was referring to had come up before this honorable court. This honorable court said, record evidence and dispose of main.
Therefore, order 21 rule 97 read with 103(4) will not come to your rescue at all. Because rights are not concluded. If rights were to be concluded, that would have become a decree by virtue of 104 or 103. 103 or 104 in the light of that Paramount Industries. But here they only said issue is being litigated before the party, between the parties, in another suit. go before there ಅಂತ ಅನ್ಕೊಂಡು ಮುಗಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು. That may not amount to a decree of the kind that would stop them from contending to the contrary. Therefore, I said, there is judgment, division bench judgment headed by Justice Ullal. ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ. ಅದೊಂದು ಕಾಪಿ ಕೊಡಿ ನಮಗೂ, ವಿಲ್ ಆಲ್ಸೋ ರೀಡ್ ಅಂಡ್ ಕಮ್ ಬ್ಯಾಕ್. ಅದೊಂದು ಸೈಟೇಷನ್ ಇಸ್ಕೊಳ್ಳಿ.
ಮಾತ್ರ ಸೆವೆಂತ್ ಬೇಡ, ಧಾರವಾಡ ಫಿಕ್ಸ್ ಆಗ್ಬಿಟ್ಟೈತೆ.
ಧಾರವಾಡ ಹೋಗಿ
Next date in. Next date in.
ಅವ್ರಿಬ್ರು ಕೂತ್ಕೊಬೇಕಲ್ಲ ಸರ್. ಸೆವೆಂತ್ ಬೇಡ ಸರ್. ಹಾ ಸರಿ,
21st ಬೇಡ, 7th 21st.
ನಾನೇ ಸರ್.
21st ನಾನು ಬೇರೆ ಕಡೆ.
ಅವರು ಒಂದ್ ಕೇಸಲ್ಲಿ ಸಾಹೇಬರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ, ಸೀನಿಯರ್ ಅವರು 885 ಅಲ್ಲಿ ಸರ್.
ಇರ್ಲಿ ಬಿಡಿ.
ಇಲ್ಲ ಇರ್ಲಿ.